Hello, everyone, and welcome to Uncivil Law. I hope you're having a great day today. And I am sure, like many of you, you saw in your various YouTube feeds that there was an unusual number of stories about trees. Lots of different trees. Many of these had the hashtag Team Trees. And I did not know this was a thing until it popped up by everyone in my YouTube feed. So many stories from so many people on trees. And Friday is becoming our Let's React to the Supreme Court Day, where we listen to oral arguments and we analyze and we discuss. And, in honor of this tree day, I thought what we would do is we'd listen to an argument that is on point. So we could do two things. We could talk about trees, or, this is Uncle Blackleaf, we could talk about trees. So let's talk about trees. Today's case is Gonzales v. Raich, referred to in oral arguments as Ashcroft v. Raich, because at the time of oral argument, Ashcroft was the Attorney General, and then at the time of the decision, Gonzales was the Attorney General, so they substitute the name. So we're going to listen to the oral argument. You notice the justices on top. Of course, this is 2004, so the justices are a little different than we know them today. So we're going to listen to this oral argument and respond accordingly. Let's get started.
We will now hear argument in Ashcroft against Raich. General Clement.
Justice Stevens, and may it please the Court. Through the Controlled Substances Act, Congress has comprehensively regulated the national market in drugs with a potential for abuse. And with respect to Schedule I substances like marijuana that have both a high potential for abuse and no currently accepted medical use in treatment, Congress categorically prohibits interstate trafficking outside the narrow and carefully controlled confines of federally approved research programs.
Well, Mr. Clement, I think it is reasonably clear that Congress spoke very broadly in the Act, and the question for me turns on whether Lopez and Morrison dictate some concerns with its application in this context.
Well, with respect, Justice O'Connor, I don't think either Lopez or Morrison cast any doubt on the constitutionality of the Controlled Substances Act. And I think in particular that's because the decisions in Lopez and Morrison cited with approval cases like Darby and Wickard and preserved those cases. And, of course, the concurring opinion of Justice Kennedy did so as well.
Of course,
Okay, so we've got a couple cases being mentioned so far. So let's talk about some of these cases that are being mentioned. We got Lopez. Lopez is a case that dealt with gun violence. The United States Congress attempted to regulate gun violence by regulating people's ability to have firearms within, I think it was 1,000 feet of a school. That case is particularly notable because it was the first case since Wickard, which you see mentioned here, and we'll get to in a second. First case since Wickard, I believe, where the U.S. Supreme Court found something to be not available to be regulated under the Commerce Clause. So Wickard v. Filburn is the case we're about to talk to in a second, was a case dealing with someone growing wheat on their own farm. And at the time, the United States government had a quota on wheat, and he was exceeding the quota. And so even though he was growing it for his own purposes on his own land, for his own cattle, he didn't sell it. It was consumed by him on his own land. Nevertheless, the Supreme Court found that this was interstate commerce. So notwithstanding the fact that the wheat itself never entered the commerce stream of any kind, it was deemed to be interstate commerce because it affected interstate commerce because he could grow it, therefore he wasn't having to buy it, and therefore that affected interstate commerce. This was the reasoning of the court in Wickard. I do not approve of this reasoning. I'm just explaining to you the case. So that's Wickard v. Filburn. Wheat grown on your own land for your own purposes is interstate commerce somehow. That's Wickard v. Filburn. Then U.S. v. Lopez was dealing with a case, as I said, about firearms violence, and it was the first case that said it was unconstitutional for Congress to do something under the Commerce Clause. U.S. v. Morrison was a case dealing with the Violence Against Women's Act, in which parts of it were similarly upheld to violate the Commerce Clause. So that's what they're talking about in those cases. So that's the landscape of cases. Wickard v. Filburn is a case that says we can regulate anything under interstate commerce, and Lopez and Morrison are two cases that says, well, maybe not so much. So that is the context of the discussion so far.
You had a wheat grower, a small farmer, and his wheat did in part go in the national market. You don't have that here. As I understand it, if California's law applies, then none of this homegrown for medical use marijuana will be on any interstate market. And it is in the area of something traditionally regulated by states. So how do you distinguish Morrison, and how do you distinguish Lopez?
Well, Justice O'Connor, let me first say that I think it might.
Oh, that didn't work. I accidentally killed the audio there, but that's no problem. We can bring it back. So, hello, Nate. It's nice to have you there. Wickard v. Filburn is a famous case. Nate Brody is a fellow lawyer. He has his own YouTube channel. You can check it out sometime when you're not listening to me. I like his arguments and discussions very much. So nice to have you, Nate. And as we discussed Team Trees, I don't know about your YouTube feed, but I've been seeing nothing but videos about trees all day long. And I decided, let's have a discussion about trees. And because it's Uncle Blackleaf, our discussion about trees is really about trees. So why not? We're going back in time and listening to some oral arguments. Let's continue where we left off.
Well, with respect, Justice O'Connor, I don't think either Lopez or Morrison cast any doubt on the constitutionality of the Controlled Substances Act. And I think in particular that's because the decisions in Lopez and Morrison cited with approval cases like Darby and Wickard and preserved those cases. And, of course, the concurring opinion of Justice Kennedy did so as well.
But in Wickard, of course, you had a wheat.
Lint asks, so who makes the video with the highlights of the justices? The highlights and justices is made by Oyez. That's Oyez. Oyez.org does these highlights of things to make it easier to follow. So thank you to Oyez.org for the highlights. Of course, the audio itself comes courtesy from the United States Supreme Court. So let's carry on.
Grower, a small farmer, and his wheat did in part go in the national market. You don't have that here. As I understand it, if California's law applies, then none of this homegrown for medical use marijuana will be on any interstate market. And it is in the area of something traditionally regulated by states. So how do you distinguish Morrison, and how do you distinguish Lopez?
Well, Justice O'Connor, let me first say that I think it might be a bit optimistic to think that none of the marijuana that's produced consistent with California law would be diverted into the national market for marijuana. And, of course, the Controlled Substances Act is concerned at almost every step of the Act with a concern about diversion, both of lawful substances from medical to non-medical uses and from controlled substances under Schedule I into the national market.
In looking at this broad challenge, do we have to assume that the state of California will enforce its law? I mean, if it turns out that it isn't and that marijuana is getting in the interstate market, that might be a different thing.
Well,
just by way of note here, Paul Clement is not only the Solicitor General at this time, but he may be the best Supreme Court advocate that ever was. He may be the very best. If you asked people who's the best lawyer, Paul Clement's name is going to come up. He still argues before the Supreme Court. He's really good. Really good. So for any of you guys who are legally minded, I would suggest listening very carefully to Paul Clement in basically anything he's ever argued, because he may do it better than anyone ever has. He's
With respect, Justice O'Connor, on this record, I don't think that there's any reason to assume that California is going to have some sort of almost unnatural ability to keep one part of a fungible national drug market separate. And I think Congress here made important findings that you've alluded to, not just that there's a national market, not just that the intrastate and the interstate markets are linked, but that drugs are fungible. And that because drugs are fungible, it's simply not feasible, in Congress's words, to regulate and separately focus on only drugs that have traveled on interstate commerce.
Well, General Clement, what if we were to assume, I'm not saying this is that the district court could find that there is a narrow segment of the market in which they could prevent diversions, and they had to say they made such findings? Would we have to disregard them or say they're irrelevant?
I think you would say they're irrelevant, Justice Stevens, and that's because...
But then why do you need to rely on the possibility of diversion?
Well, because I think it is a reality in responding to Justice O'Connor's question. I think that obviously in all of these commerce clauses...
But my hypothesis, it's a non-existent reality.
Well, in your hypothetical, and if I could turn to that, I still think the analysis would not turn on whether or not the truth of the supposition that diversion could be prevented. Because this Court, in a series of cases, including Darby, Wickard, Wirtz, and Perez, has made clear that the relevant focal point for analysis is not the individual plaintiff's activities and whether they have a substantial effect on interstate commerce, but whether the class of activities that Congress has decided to regulate has such a substantial effect. And in this case, there's no question that the overall production, distribution, and possession of marijuana and other Schedule I substances has a profound effect on interstate commerce.
I think Clement is right about the state of the law in terms of that. It is basically the class. It's not the issue is if everyone did it, right? So even going back to Wickard, where it's the guy growing wheat on his own land for his own purposes, the problem is that if everyone did that, then it would obviously impact the interstate commerce market. If everyone grew their own wheat, there'd be less of it being bought on the interstate market because people would need less. Personally, I'd say that's kind of beyond Congress's purview. If people want to grow wheat or tomatoes or basil or trees on their own land for their own purposes, then personally, I don't really think that's any business of the federal government's, but he's correct. That's an accurate statement of the law.
Not an interstate commerce that you want to foster. I mean, in these other cases, Congress presumably wanted to foster interstate commerce in wheat in Wickard versus Filburn. Congress doesn't want interstate commerce in marijuana, and it seems rather ironic to appeal to the fact that homegrown marijuana would reduce the interstate commerce that you don't want to occur in order to regulate it. I mean, doesn't that strike you as strange?
Well, no, it doesn't, Justice Scalia, but let me respond in two ways. First of all, I think it's been clear, at least since the lottery case, that Congress's authority to regulate interstate commerce includes the authority to prohibit items traveling in interstate commerce and to declare something contraband in interstate commerce.
Absolutely.
And I would suggest that it is a perfectly rational exercise of Congress's judgment to treat marijuana and other Schedule I substances not just as contraband in interstate commerce, but as contraband simpliciter, as contraband for all purposes.
But that's quite a different rationale than from Wickard versus Filburn. I mean, it seems to me you're not appealing to the fact that it has a substantial impact on interstate commerce. You're appealing to the fact that the power which Congress has to prohibit the use of goods carried in interstate commerce, it cannot effectively be implemented without this law.
Well, I think there's some truth to that, Justice Scalia, but let me say this. I think what I'm saying is I'm taking the rationale that this Court accepted in Wickard and I'm applying it to a different regulatory regime. Here, Congress is not primarily...
the opposite kind of regulatory. You're applying it to a regulatory regime in which the government wants to prohibit this substance from being sold or in interstate commerce. And if you just follow the letter of this law, this marijuana won't get into interstate commerce. In fact, it would reduce the demand for marijuana because it would supply these local users and they wouldn't have to go into the interstate market.
Well, with respect, Justice Stevens, if you took a look at the Controlled Substances Act itself and read it literally, you'd assume that there was absolutely no market, period, in Schedule I substances. But the reality is there's a $10.5 billion market, illegal market, albeit, but market in marijuana in the United States.
You know, one could argue that if there's a $10.5 billion market, and this is in 2004, if there's a $10.5 billion market, maybe, there are other policies we could adopt other than trying to ban it. Because, apparently our attempts to ban marijuana have been somewhat less than successful if there's a $10.5 billion nationwide market. So, saying something's illegal, apparently people might still do it anyway. So maybe a different policy might be advisable. Just some thoughts for the peanut gallery here.
on an annual basis.
But to the extent that this statute has any impact, it will reduce the purchase in the interstate market and confine these to locally grown marijuana.
Well, first of all, Justice Stevens, that's only true if there will be no diversion, to get back to your assumption.
Then I'm assuming my hypothetical is that California could pass a law that would prevent diversions from occurring.
Well,
Manitoban Misanthrope says cannabis needs to come off Schedule 1. I agree, not for the least of reasons that according to the law, which is something we should be theoretically following, right? In order for something to be Schedule 1, it has to have no medical use, by definition. Does marijuana have medical use? I would tend to think so. If you want to know why, despite you thinking it has medical use, it doesn't have medical use, I would recommend reading the DEA's paper on the subject that came out just before the end of the Obama administration. Just before the end of the Obama administration, the DEA wrote a I forget exactly how it was styled, but wrote this very long paper basically on why marijuana being illegal is a good thing. And it is a really, really well-written paper. You know the answer is marijuana should still be illegal. And it's like, well, how do you justify that conclusion? If you want to know how to justify things that are really hard to justify, I recommend reading it because it was just expertly done. Brilliant work by the DEA trying to justify the impossible. So, I really admire that because they had a position and by God, they did their best to defend that castle. So if you ever want to read it, I recommend that's a good place to go.
In the same way that the federal government has had trouble stamping out the marijuana market entirely, I think California is going to have parallel problems in absolutely preventing diversion. But just
I suppose one answer to that case is the Perez case with loan sharking.
Oh, absolutely, Justice Kennedy. And in that context, what this Court said is even though it was focused on what was going to be both in that case and generally an intrastate activity, Congress did not have to just look at the particular plaintiff's effect on interstate commerce, but rather the effect of the entire class of activities. And
as Justice O'Connor brought out earlier, all those cases, Wickard, Perez, they all involve a commercial enterprise. And here we're told this is different because nobody is buying anything, nobody is selling anything.
Well, with respect, Justice Ginsburg, I think the whole point of the Wickard case was to extend rationales that had applied previously to commerce to activity that the Court described as economic but not commercial. And I think the production and distribution and possession of marijuana is economic in the same way that the production of wheat was in the Wickard case.
But I was going to say, your whole point, I take it, is that the two particular patients in this case are simply cannot be taken for our purposes as representative in the fact that they're getting the marijuana by either growing it themselves or being given it. You're saying you cannot take that fact as a fact from which to generalize in deciding this case.
That's exactly right, Justice Souter, and that is the logic not just of me, but of this Court's cases, in cases like Darby and Wickard and Wirtz and Perez. And I point to the Wickard case in particular only because it, too, involves a non-commercial enterprise or a non-commercial production of wheat.
Well, I do take issue with that. As I read the record in Wickard, it involved a small farmer. A portion of his wheat went on the interstate market. It also was fed to cattle, which in turn went on the interstate market. He used some of it himself, but part of it was commercial. I think Wickard can be distinguished on the facts.
Well, Justice O'Connor, it could be any case can be distinguished on the facts, of course, but I think what's important is this Court in Wickard itself recognized that the case was only interesting because a portion of the regulated wheat involved wheat that was going to be consumed on the farm. And
State commerce.
Well, that's true, Justice O'Connor, but with this Court basically, in its opinion, Justice Jackson for the Court put aside to one side all of the grain that was going to go in interstate commerce and said that's easy under our existing precedents. This case is only interesting, he said, because it involves wheat that's going to be consumed on the farm. And he specifically talked about both the wheat that would be fed to the animals, but also the wheat that would be consumed by the family. And what he said is the intended disposition of the particular wheat wasn't clear from the record of the case. And by that, I take him to mean that it wasn't relevant to the Court's analysis in upholding the Agricultural Adjustment Act to the wheat at issue there. And it's important to recognize that the way the Agricultural Adjustment Act worked is it applied to all the wheat that was grown in excess of the quota. And so it applied to the wheat that was used by the family for consumption of their own bread. And nonetheless, this Court upheld that as
Mr. Lynch says, does O'Connor just say that anything that might be on the interstate market, no matter how derivative the market, makes all things as being on the interstate market? Yep, pretty much, and that is a reasonable summary of the state of the law, especially before Lopez. But yeah, it's a reasonable statement of the law that everything is interstate. Everything is interstate commerce. It's impossible, and all non-commerce is interstate. So all commerce and all non-commerce is interstate because all commerce impacts state choices and things that will flow over state lines. This is one of the reasons that people such as myself bristle very deeply at Wickard v. Filburn, because it's like, wait a second, someone doing something on their own land for their own purposes constitutes interstate commerce because in gross it would affect interstate commerce. This is like why when I read federal statutes and they say, and they have as an element of the crime, blah, 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 affecting interstate commerce, I pretty much just ignore that clause completely because it's like, how could it not? So it's a meaningless proviso in my view. So, yeah.
As a valid Commerce Clause regulation. And so I think by parity of reasoning, all of the marijuana that's at issue and covered by the Controlled Substances Act, whether it's lawful under state law, whether it's involved in a market transaction or not, is fairly within the Congress's Commerce Clause authority.
Is this a harder or easier case than Wickard when we know that in Wickard it was lawful to buy and sell wheat, and here it is unlawful to buy and sell marijuana?
Well, Justice Kennedy,
does this make your case easier in a sense?
I think it does, Justice Kennedy, because as I said earlier in responding to a question from Justice Scalia, I think if you're talking about a context where Congress has the undoubted power to prohibit something in interstate commerce entirely and has exercised that power, so it treats something as effectively contraband in interstate commerce, and then takes the complementary step, especially in light of the fungibility of the product, and says, we're just going to treat this as contraband simpliciter. I think that judgment by Congress has a very definite link to interstate commerce and its unquestioned authority to regulate interstate commerce. And I do think there's a sense in which when Congress is regulating the price of something, there's certainly a temptation to excise out relatively small producers and for Congress to say, well, we can still have effective regulation if we regulate the vast majority of production. But with respect to something that's unlawful to have and has very significant risks precisely because it's unlawful, any little island of lawful possession of non-contraband marijuana, for example, poses a real challenge to the statutory regime. It would also, I think, frustrate Congress's goal in promoting health. And I think the clearest example of that is the fact that
query, which provision of the Constitution gives the Congress of the United States power to promote health as a goal unto itself? Yeah. To
the extent there is anything that is beneficial health-wise in marijuana, it's THC, which has been isolated and provided in a pill form and is available as a Schedule III substance called Marital.
But there is, in this record, a showing that for at least one of the two plaintiffs, there were some 30-odd drugs taken. None of them worked. This was the only one that would. And Justice Souter asked you about these two plaintiffs. The law can't be made on the basis of those two plaintiffs. But let's suppose that you're right generally. If there were to be a prosecution of any of the plaintiffs in this case, would there be any defense if there were to be a federal prosecution?
Well, Justice Ginsburg, I think we would take the position based on our reading of the Oakland cannabis case. And obviously different justices on this court read the opinion differently and had different views on the extent to which the medical necessity defense was foreclosed by that opinion. I would imagine the federal government in that case, if it took the unlikely step of bringing the prosecution in the first place, would be arguing that on the authority of Oakland Cannabis, the medical necessity defense was not available. But I think in any event, what is important at this point is that we don't have a prosecution. We have an affirmative effort to strike down the Controlled Substances Act in an injunctive action. And I think in that context, certainly Justice Souter's right that this Court's precedents make clear that one doesn't consider only the individual's conduct, but the entire class of activities that's at issue. I think in this regard, it's also worth emphasizing that a deeper flaw in the respondent's argument that California law is somehow relevant here, or the fact that their conduct is lawful under California law, is that there's a mismatch between what California law makes lawful and what might be considered relevant for arguing that there's an attenuated effect on interstate commerce. Because the California law makes the possession of marijuana for medical use lawful under state law without regard to whether that marijuana has been involved in a cash transaction or it's crossed state lines. And so if respondents are right in their Commerce Clause theory, I don't see how they can be right because their conduct is lawful under state law or because their marijuana use is medical. If they're right, then I think their analysis would extend to recreational use of marijuana as well as medical use of marijuana and would extend to every state in the nation, not just those states that made it lawful.
Doesn't it depend on how you define the relevant class of activities? Is it the entire class that Congress ought to regulate, or is it a narrower class in which the plaintiffs contend that the statute cannot constitutionally be applied to a particular very narrowly defined class? And is it ever permissible to define the class narrowly to escape the broad argument that you make?
Well, I don't think that is permissible, Justice Stevens. I think that's what this Court's cases in Wirtz, in Darby, and Wickard stand for.
This statute could never have an unconstitutional application.
Under the Commerce Clause. That's exactly right. That would be our position. It is constitutional on its face, and because of that line of authority, an as-applied challenge can be brought, but the legal test that's applied in the as-applied challenge is one that considers the constitutionality of the statute as a whole.
But in Morrison, did the Court's opinion not say that Congress cannot justify Commerce Clause legislation by using a long but-for causal chain from the activity in question to an impact on interstate commerce? I mean, the Court certainly made that statement.
Oh, absolutely, Justice O'Connor.
Which cuts against what you're saying.
Well, with respect, I don't think so. And I'd say two things about it. One, this Court in Morrison and Lopez was very important to emphasize, thought it was very important to emphasize two things. One, that the activity there was non-economic in a way that differentiated it even from Wickard. And second, the Court also made it clear that the regulation there was not essential to the effectiveness of an overall regulatory scheme. And I think on both points, this case is on the constitutional side of the line that separates the Lopez and the Morrison case.
The argument on the other side is that this limited exception is a non-economic use, growing for personal use under prescription.
I understand that's their argument, Justice O'Connor, but I don't understand how this Court in Lopez could have said that Wickard involved non-economic activity if this activity is not also covered. You're talking about
involved economic activity.
I'm sorry if I misspoke. Economic activity, because what you're talking about here is the possession, the manufacture, the distribution of a valuable commodity for which there is unfortunately, a ready market, albeit an illicit market.
If we rule.
Marauder asks, even if we can see there's no medical value despite the contrary, what's really so evil that must be banned while tobacco and alcohol is perfectly legal for adults? I agree with you on the philosophical nature of your question. I think that's a very fair question, especially since marijuana has much fewer death casualties than either of the substances that you name. No matter how you measure death casualties, it's not there. Now, I do have an interesting argument, which I don't know if anyone's ever actually tried in court, and maybe Nate, if he's still floating around out there somewhere, can tell me if he thinks it's a good idea or a bad idea, because I want to write a law review on this at some point, because I have this idea that, because people have tried to say the federal government doesn't have the power to ban marijuana using various constitutional provisions. But I have this idea under the 18th Amendment. All right. So the 18th Amendment, for those of you who may forget, is the one that created prohibition. It, of course, was since repealed by the 21st Amendment. But here's the legal argument I want to try to make and see if this will fly. The 18th Amendment to the Constitution not only did something substantive in terms of the substance of banning alcohol, it also codified implicitly a legal judgment. What is legal judgment? Here's the argument. The legal judgment is that the people at the time did not think that they had the power to ban alcohol by mere legislation. They believed that in order to ban alcohol, they needed a constitutional amendment. They believed the Commerce Clause did not give them the authority to ban alcohol. And for this purpose, they needed to amend the Constitution of the United States to ban alcohol. And even though the 21st Amendment repealed the substance of the 18th Amendment, the argument would be it did not repeal the underlying legal judgment of the 18th Amendment. And therefore, Congress doesn't have the power to regulate marijuana under the Commerce Clause, because even if it did originally, the 18th Amendment to the Constitution reflects a judgment of the people that the Congress cannot regulate alcohol by statute and implicitly cannot regulate marijuana by statute. That is the line of argument that I'd like to try. And I don't know if anyone's ever tried that line of argument in court, but I think it's an interesting line of argument. And, you know, I think it might be interesting. So, Nate, if you agree with me, maybe you can help me. Maybe we can team up and write a law review on the subject, because I think it would be a really interesting thing to explore if I can make that argument fly, and maybe give someone the motivation to bust out basically all of drug policy using this line of reasoning. So, could be fun.
For the respondents in this case, do you think the street price of marijuana would go up or down in California?
I would be speculating, Justice Kennedy, but I think the price would go down. And I think that in a sense is consistent with the government's position, which is to say, when the government thinks that something is dangerous, it tries to prohibit it. Part of the effort of prohibiting it is going to lead to a black market where the prohibition actually would force the price up. And there is a sense in which this regulation, although not primarily designed as a price regulation, the Controlled Substance Act, I think, does have the effect of increasing the price for marijuana in a way that stamps down demand and limits and in a way that reduces demand. And I think that's all consistent with Congress's judgment here. And if I could return for a second to the point about Marinol, what's important there is that the process of manufacturing of Marinol and isolating the one helpful component does two things. One, the manufacturing process allows there to be a safe use for one of the components in marijuana. But it also provides an unambiguous hook for Congress to exercise its Commerce Clause authority. And yet the overall regime of trying to get people to use more healthful substances and not use things like crude marijuana that have harmful effects is undermined if Congress can't also address that which is more harmful but is distinct only because it is capable of being locally produced. And that's exactly what crude marijuana is.
In other words, the statute trumps the independent judgment of the physicians who prescribe it for the patients at issue in this case.
Well, I think in responding to that, Justice Stevens, I would say obviously from purposes of federal law, the idea of medical marijuana is something of an oxymoron because the federal government treats it as a Schedule I substance. Now, notwithstanding that, some doctors may make a different judgment about a particular patient. But that's something that this Court, I think, has previously understood, that the federal regulatory regime does not allow individual patients or doctors to exempt themselves out of that regime. I think that's the import of the Rutherford decision with Laetrile.
Do you think there could be any state of facts on which a judicial tribunal could disagree with the finding of Congress that there's no acceptable medical use? Say there was a judicial hearing in which they made a contrary finding. Would we have to ignore that? Would we have to follow the congressional finding or the judicial finding if that happened?
Well, it depends on the exact hypothetical you have in mind. I think the judicial finding that I think would be appropriate, and this Court would not have to ignore in any way, is a finding by the D.C. Circuit that in a particular case where there's a rescheduling effort before the FDA, that the underlying judgment of the FDA refusing to reschedule is invalid, arbitrary, capricious. That's the way to go after the finding.
So a couple responses to my thoughts. Someone said it was high risk, high gain. Might not be a good idea to try to break all drug policy. Well, if you want to try to avoid breaking all drug policy over my line of reasoning, here is a supplemental line of argument to try. You would say that the time at the 18th Amendment, at the time of the 18th Amendment, and my webcam just froze. Unbelievable. This has been happening to me periodically. Hold on. I'm not actually frozen. Sorry. I apologize for the problem. This has been happening to me for a little bit. I'm not sure why. And we're back. All right, let's try this again. So the way to prevent this from breaking everything is you would say at the time of the 18th Amendment, it reflected a judgment that banning alcohol was not within the purview of Congress. The way to solve this problem is to say that alcohol was something that was known at the time of the 18th Amendment. Other things that would be known at the time of the 18th Amendment would be such things as marijuana and tobacco, for example. And so the line of reasoning would prevent the government from banning it altogether. Now, the 18th Amendment doesn't speak to regulation. It speaks to banning. So the 18th Amendment, so you could say that the 18th Amendment does not reflect a judgment that Congress doesn't have the authority to regulate even alcohol. But to ban it, you need a constitutional amendment. The way you solve that problem when it comes to other drugs is that a lot of other drugs were not known at the time. So you would say, like 1918, what drugs were known historically? So things like meth, for example, you could throw out of this analysis because they were not known at the time. And so you could try to differentiate the more synthetic drugs on the basis that the judgment of what Congress can and cannot do with respect to drugs within the meaning of the Commerce Clause based on the 18th Amendment's rationale only extends to drugs that were known at the time of the 18th Amendment, which would be 1918. So I can essentially freeze all the synthetics that came after 1918. And so, yeah, I got that going for me. So that's one way to solve that problem, is trying to go to a time period based rationale. Tactical Bra says she came here thinking it'd be about actual trees. I put the word trees in quotes, Tactical. It was kind of a clue.
That marijuana is a Schedule I substance without a valid medical use and treatment. This is not a situation, and your hypothetical might respond to a different statute that raised a harder question, where Congress made such a medical finding and then just left it there without any mechanism to adjust the finding for changing realities. But here Congress made it clear that a process remains open to reschedule marijuana in a way that gets it onto Schedule II or Schedule III. And I think it's wrong to assume that there's any inherent hostility to the substances at issue here. I mean, the FDA, for example, rescheduled Marinol from Schedule II to Schedule III in a way that had the effect of making it easier to prescribe and more available. But I think what's going on with the FDA is an effort to try to counterbalance the risk for abuse, the risk for diversion, with these other considerations of getting safe medicine available to patients.
Have there been any applications to change the schedule for marijuana to the FDA?
There have been a number of those petitions that have been filed. There was one recently rejected, I think as recently as 2001, it may be 1999. There was also a series of kind of a 4 or 5 iteration effort to change the rescheduling that culminated in a D.C. Circuit opinion in the early 90s. So there's definitely been these efforts, but on the current state of the record, there just is not a justification for changing the schedule.
You gotta love that answer. I don't fault Paul Clement for giving that answer, because he kind of has to give that answer. But it's like, as Lint, I think, was pointing out earlier, one of the reasons there's not justification for changing the schedule is because the federal government has severely restricted any attempts to study marijuana in order to determine whether or not it should be on the schedule. So yeah, it's a bit of circular reasoning there. So it's like, there's no justification for changing the schedule. Well, at least in this commentator's humble opinion, there needs to be continuing justification for it to be on the schedule. So that it's not a justification to change the schedule. The justification should be to keep it on the schedule. And what's the justification to keep it? Maybe we should do research on that, which would fall apart. That's one of the reasons the government doesn't want to do it, I'm sure. So yeah, good times. Your studies in Canada don't count, Tactical. No, studies done anywhere in the world don't count. You know, all those studies that were done in other countries and those researchers, none of those researchers count. You dirty Canadians with your dirty research, you guys cheated at all your research. You guys don't know how to do academic research. It's all dirty, dirty research. We can't trust it in you hippie commune pot smoking Canucks. So, you know, go back to Canada with your research. We're not interested in that over here. There's no justification. We don't want to look at your papers. You guys are a bunch of criminals. Our neighbors up north. That's how you're up. That's how you got up north, right? Smoking so you got so high. That's how you got north, right? We don't want none of that here, Canadians.
And I think both of the briefs talked a little bit about the Institute of Medicine study about the medical efficacy of marijuana. And I think one thing that's important to keep in mind that study comes to a conclusion about is that whatever benefits there may be for the individual components in marijuana, that smoked marijuana itself really doesn't have any future as medicine. Because, and that's true, I think, for two reasons. One, there's something like 400 different chemical components in crude marijuana that one would smoke. And it's just sort of belies any logic that all 400 of those would be helpful. And a big part of the process of medicine generally is to take raw, crude material that somebody could grow in their garden and actually have people who do this for a living get involved in a process of synthesizing and isolating the beneficial components and then manufacturing and making that available. The second reason that smoked marijuana doesn't have much of a future as medicine is as I think people understand, smoking is harmful. And that's true of tobacco, but it's also true of marijuana. And so the idea that smoked marijuana would be an effective delivery device for medicine, I think, is also something that really doesn't have any future as medicine. What does have a future for medicine, of course, is an effort to synthesize and isolate the beneficial component. That's been done with Marinol. It is.
Hey guys, you have Marinol. That's all you need. This wonderful drug, Marinol. Registered trademark.
True that some people have difficulty tolerating the pill form that Marinol is available in. And there's ongoing research to try to figure out different ways to deliver that substance. But there is, in a sense, a little bit of, in the Institute of Medicine study has about 5 pages discussing Marinol, and it makes the point that there's something of a trade-off, because one of the downsides of Marinol as opposed to marijuana is that it takes longer to get into the bloodstream. But that's also one of the reasons why the FDA has made a judgment that Marinol is less subject to abuse, because it takes longer to get into the drug stream, and so it doesn't have the characteristic of street drugs that tend to be abused, which is a very quick delivery time between the taking of the substance and the time that it has an effect on the system.
May I go back to your point a few minutes ago about sort of a category point? You, in effect, said if this argument succeeds with respect to medical use of marijuana, the next argument is going to be recreational use, and there's no real way to distinguish between them. Wouldn't this be a way to distinguish between them? That in deciding what class you are going to, or what subclass you're going to consider from which to generalize, you simply ask the question, what good reasons are there to define a subclass this way? In this particular case, the good reasons to define a subclass of medical usage are the benefits, whether you accept the evidence is another thing, but the benefits which the doctors say that under present circumstances you can get from smoking it as opposed to taking the synthesized drug. There's no such argument, I would guess, in favor of recreational marijuana usage as a separate category. And for that reason, isn't there a good reason to categorize this as narrowly as the respondents are doing here, just medical usage without any risk of generalizing to recreational usage?
With respect, Justice Souter, I don't think that it would be a good idea for this Court to get on a path of starting to second-guess Congress's judgment about defining the class of activity.
That may be, but it seems to me that that's a separate argument, because you were arguing before that if you recognize medical usage, you don't have any way of drawing the line against private recreational usage. And I'm suggesting that you do have a reason for drawing that line, and it's the benefit from medical usage if you accept the evidence, whereas there is no reason to categorize recreational usage separately. And that seems to me a category argument rather than a respect for Congress argument.
Well, Justice Souter, I have no doubt that this Court could draw a line. I think it would find it very difficult to police that line over the broad variety of cases. I think it would find it every bit as frustrating as policing the line in Hammer against Dagenhart that this Court abandoned in Darby. With that, I'd like to reserve my time for rebuttal.
Mr. Barnett.
Marauder says second-guessing Congress's judgment regarding medical validity. So Congress is full of doctors now? I don't know what to tell you, man. State beats doctors. Your doctor says it has medical use. Congress says no, it doesn't. And so I guess no, it doesn't. We've all been tragically misinformed by the variety of medical professionals, both in this country and medical professionals in other countries with their shipshod medical schools and flimsy research and fly-by-night practices and so forth and so on. So, we don't really care what any of those hippie, dippy, freedom-loving people. Wait a second. I thought we were in favor of freedom in the United States. Whoops, I said too much. Let's press on.
Justice Stevens, and may it please the Court, I have 2 points to make. First, the class of activities involved in this case are non-economic and wholly intrastate. Second, the federal prohibition of this class of activities is not an essential part of a larger regulatory scheme that would be undercut unless the intrastate activity were regulated. If you accept the government's contrary contentions on either of these 2 points, Ashcroft versus Raich will replace Wickard versus Filburn as the most far-reaching example of Commerce Clause authority over intrastate activity.
Well, on your first point, can't we infer from the fact that there's an enormous market, commercial market, for any given commodity, that simple possession of that commodity is a form of participation in the market?
It can be, or it might not be. If you possess an item that came from the market or is going to the market, simple possession could easily be a part of the marketplace. But if you're in possession of an item that you've made yourself that is disconnected from the market, it didn't come from the market, and it's not going to the market.
But it's fungible.
That the fungibility issue is in this case. But the fact that a good is fungible does not make it a market good, and it does not make the possession of that good an economic activity.
Well, Congress.
This lawyer, Randy Barnett, he's also a really smart guy. I think he's Cato. I want to double check that, but I know he's a really smart guy. Yes. He's Georgetown University legal theory, teaches constitutional law. And I think he might work for Cato or something. He works Federalist Society. Yeah, he's a senior fellow of Cato and Goldwater Institute. So, yeah, he's a really, really smart lawyer. He's a guy worthy of paying attention to. He's also a commentator on the blog Volokh Conspiracy. If you want to go read legal stuff, he's a commentator on that. He's a really, really sharp guy. He's worth listening to. So we have a bunch of really smart lawyers on this. We have Paul Clement, who's like one of the best, and we got Randy Barnett arguing for the other side. He's one of the best too. He's not as good as Clement, but he's really sharp. So he's a guy worthy of paying attention to.
Congress has applied this theory in other contexts. One is the protection of endangered species. Congress has made it unlawful to possess ivory, for example. Doesn't matter whether you got it lawfully or not. Or eagle feathers. The mere possession of it, whether you got it through interstate commerce or not. And Congress's reasoning is we can't tell whether it came through interstate commerce or not. And to try to prove that is just beyond our ability, and therefore it is unlawful to possess it, period. Now, are those laws likewise unconstitutional as going beyond Congress's commerce power?
Not if they're an essential part of a larger regulatory scheme that would be undercut unless those activities are reached.
Why is that different from this?
Because this class of activities, because it's been isolated by the state of California and is policed by the state of California so that it's entirely separated from the market.
Isolated and I understand that there are some communes that grow marijuana for
communes, baby,
for the medical
hippies.
use of all of the members of the communes.
That class of activities is not before the court. That is actually before.
Oh, but it's before the court when you raise the policing of the problem by California and saying it's not a real problem. You brought it before the court.
But that class of activities could be if this court limits its ruling to the class of activities that is before the court.
Which is what?
Which is
an individual grower?
Individual who is growing it for him or herself, who has a caregiver growing it for her.
Gee, what basis is there to draw it that narrowly? I mean, I guess we could say people whose last name begins with a Z. You know, that would narrow the category too. But why does that make any sense?
Justice Scalia, we believe it makes sense because we are talking about a classification of activities that has been identified by the state of California and which is rational to distinguish
but
from.
But California hasn't identified individual growers. Communes are okay as far as California law is concerned.
Well, it's not entirely clear whether communes are okay as far as California.
Why wouldn't it be?
Because if, in fact, commercial activity is taking place, if buying and selling is taking place.
No, they're not buying and selling. I mean, you can't prove they're buying and selling. There's just a whole lot of people there with alleged medical needs.
I don't understand. Is there any authority in the Commerce cases for an X which is there in the middle of a state? It doesn't move one way or the other. Now, Congress's power does extend to the X if the state doesn't say something about the X. But if the state says something about the X, then Congress's power does not extend to it. That's hard for me to accept because I don't see whether it's commerce or not commerce, whether it affects something or doesn't affect something, doesn't seem to me to have much to do whether the state separately regulates it, and I can't find any support at all for that in any case.
The support would come from the exception to Lopez and Morrison that the government is urging that the court adopt, that the Congress can reach non-economic activity that's intrastate, that's wholly intrastate, if doing so is essential to a larger regulatory scheme that would be undercut if they can't reach it.
Well, here they say, look, I take it you're using this because I was going to ask you. You know, he grows heroin, cocaine, tomatoes that are going to have genomes in them that could at some point lead to tomato children that will eventually affect Boston. You know, oil that's never, in fact, being used, but we want an inventory of it federally. You know, I can multiply.
Tomato children? Tomato children? So was Attack of the Killer Tomatoes more of a documentary? I guess. Carrying on.
By the examples. Well, and you can too. So you're going to get around all those examples by saying what?
By saying that it's all going to depend on the regulatory scheme, what the purpose of
So now what you're saying is in a Commerce Clause case, what we're supposed to do is to start to look at the federal scheme and the state scheme and see, comparing the federal scheme and the state scheme, whether given the state scheme, the federal scheme is really necessary to include this. That's a task, and I'm trying to make it as complicated as I can in my question. But I see it
good job.
Very well. Here's what they say. They say that, by the way, 100,000 people using medical marijuana in California will lead to lower marijuana prices in the nation. Bad. And second, when we see medical marijuana in California, we won't know what it is. Everybody will say, mine is.
Justice Breyer, man, he does this all the time with these questions. He has these really long questions with these hypotheticals and lists a lot of stuff, man. Justice Breyer, man, oh man.
Medical. Certificates will circulate on the black market. We face a mess. For both those reasons, it does have an impact, they say. Now, what's your response?
Well, you've raised at least two different practical issues. One is the number of people who are in the class, and the second is the ability to identify.
Higgins says, because if everyone grows it on their own, it'll lower prices elsewhere, thus affecting commerce. 100% correct. And you're basically on board with Wickard v. Filburn. That is essentially, in so many words the rationale of Wickard v. Filburn, where this all started. If he grows wheat on his land, then there will be less demand for wheat, and that would affect the price in interstate commerce. Therefore, it affects interstate commerce. So if you're saying to yourself, that's ridiculous, you're saying Wickard v. Filburn is ridiculous, and welcome to the club in saying Wickard v. Filburn is ridiculous. I agree with you. It's ridiculous. It's ridiculous as the day it was decided. It makes no logical sense, and it has been used and extended and abused for years and years and years to justify all manner of things. Because yeah. So anything Higgins says anything that's traded on an open market is covered by congressional jurisdiction, and also anything that's not traded on the market, because anything not traded, well, if you start trading it, that'd be market. So anything that's on sale could be on sale, couldn't be on sale, not on sale. These are all grown for yourself on your own land, sold to your neighbors in your own state, for your own purposes, your own time, not grown, things you're not doing. I mean, this was one of the arguments for the Obamacare, for the Obama healthcare plan, was that people not buying health insurance was interstate commerce. Now, fortunately, the conservatives disagreed with it. They said it was part of the taxing authority, although the 4 liberal justices want to say that not buying health care was affecting interstate commerce. And that's Wickard, basically. So, yeah, welcome to the club, man. And the progressive members of the court still think, to this day, it's all good. Buying stuff, not buying stuff, it's all fine. So, yeah, carrying on.
By whether they properly belong in the class. As for the number of people, we are talking about a very small number of people. They say 100,000. They get their figures from the National Organization for Reform of Marijuana Laws. Our figures in our brief come from the government. The figures show it's a very small fraction of persons that would be involved. And their argument is basically, and the logic of your hypothetical is premised on the more people that go into the illicit market, the better for federal drug policy, because that will drive the price up. You have to, what we're doing is we're taking people out of the illicit drug market, which then, under your hypothetical, would lead to a reduction, and Justice Kennedy's suggestion would lead to a reduction in the price of the illegal market, which the opposite would be. It's good for federal policy to have more people in the illicit drug market, because that's going to drive the price up.
No, we don't want more people in the illicit drug market.
Of course not.
And we don't want low prices either.
But the scheme, the class of activities that have been authorized by the state of California will take people out of
So normally I would have said it's up to Congress to figure out how to weigh that. You have one going one way, one going the other way, and balancing those factors would be for Congress. That's what we'd normally say.
I just would like to note, I would like to ask, this is just sort of a question. I'm not even sure who I'm asking it to, but I'd like to know, with the Democrats in control of the House, have they been proposing bills to decrease marijuana? I mean, I don't remember them ever, because there have been certainly periods in our nation's history when Democrats had the House, Senate, and the presidency. There was even a period there for a little bit, for 8 months, where they had a supermajority in the Senate. I don't remember them trying to say that weed should be decriminalized when they had control of the government there. I don't remember the House now circulating stuff. So I don't see a lot of calls from the left to do this either. It's really annoying. I'm not sure why we love it being illegal so much. Personally, I think that we are free people. And one of my principles is we're free people. And if we're going to make something illegal, there needs to be a justification for it being illegal. And what's the justification for marijuana being illegal? Hard to come up with one, especially in light of tobacco and alcohol being legal. It's I don't get it. I just don't understand, why they don't want to do it. I mean, they're always the ones talking, especially on the left progressive wing. They're always the ones talking about the school to prison pipeline. They're always talking about criminal justice reform. But I'll remember them a lot of pushes to legalize marijuana from the U.S. House. So I don't know, man. It's frustrating.
Well,
you say all that stuff is not for Congress, that's for us.
Well, within this exception, the threshold issue, I do want to make sure that I focus on this. The threshold issue, which is the issue that has occupied most of our time so far, is whether the activity here is economic or non-economic. The government claims it's economic, we claim it's non-economic.
Well, what it is it's non-economic, and it affects the economic.
Right. So the threshold issue that upon which Lopez and Morrison turns is whether it's economic or non-economic.
Well, I should have thought that regular household chores, say performed in an earlier time, mostly by women, was classically economic. Washing dishes.
Juan asks, is it possible because tobacco lobbyists were scared that Winston and R.J. Reynolds will lose their business? Man, I don't know about you, but I think that if marijuana became legal, Winston and R.J. Reynolds would be thrilled. Because it gives them another market for them. You know, people are not so thrilled about cigarettes, but I think Marlboro would have marijuana cigarettes on the market in no time flat. I mean, it's a brand new market for them and something people want to buy. I mean, I think they'd be thrilled, you know, and they could come up with all kinds of things. I think they would love it, you know, at least as far as I can tell. Yeah, the people seem to be pharma. That seems to be the big issue. But I don't even think it's pharma that's the issue. I think it's a combination of just, you know, the friction of doing something. It's just, you know, the ball has been this way for so long and no one wants to move it. And I think it's also like that, you know, things being illegal are just too profitable in terms of people going to jail and people needing things. It's like if we made it legal, we would need less police officers. The police officers would have less justifications to conduct searches. We need less prisons. We need less courts. So I think it's more about keeping the prison industrial complex alive, really, more than even pharma. I'm not sure pharma really cares that much because I think pharma will still be able to sell lots of drugs to lots of people. I think the tobacco companies will be thrilled. I think it's about the prison industrial complex, but that's my opinion as to what is the motivating factor. So, yeah.
It's making bread. And now you say growing marijuana isn't?
If you accept the government's definition of economic, then washing dishes today would be economic.
No, but
that
even
would be within the power of Congress to reach.
But even if we accept your definition of economic, I don't see that it is a basis upon which we ought to make a category decision. You say it's non-economic because one of these people is a self-grower, another one is getting it from a friend for nothing. But I don't see what reason that you have given or any reason that you haven't given for us to believe that out of, and I'm going to assume for the sake of argument, 100,000 potential users, everybody is going to get it from a friend or from plants in the backyard. Seems to me the sensible assumption is they're going to get it on the street. And once they get it, under California law, it's not a crime for them to have it and use it. But they're going to get it in the street. Why isn't that the sensible assumption here?
Well, they have a very strong incentive not to get it on the street because getting it on the street is going to subject them to criminal prosecution under both California and federal law. It's
also the case that approximately 10% of the American population is doing that every day. If I accept the figures in the government's brief, and they're not getting prosecuted.
But in that case, we're talking about people who are using it for sport, for recreation. We are talking about a class of people here who are sick people, who don't necessarily want to violate.
And if I am a sick person,
I think the number one biggest factor, keeping marijuana illegal. And look, guys, if you still want to say it's big pharma or other people that are the issues, I mean, I think we can agree there are a lot of people with potential interest in this. But I really think the real big support for marijuana being illegal is your average run-of-the-mill police officer. Because I smelled marijuana, regardless of whether or not they did or not, is used as a massive justification for conducting all kinds of searches in which they can find all kinds of evidence and or monies that they can seize in a process we call civil asset forfeiture, which is super popular. That, you know, so the reason marijuana is legal is because, to borrow a phrase from someone who made the Pokemon reference earlier in chat, it's super effective at being able to get to people for all kinds of stuff. So it becomes a hook to search all kinds of stuff, to search them, harass them, exert power, and all kinds of shit. So I think it is probably the police and police unions who are the most, not necessarily because they want to throw people in prison per se, but just because they use it as a tool of their power. So I think that's probably the dominant factor. But if you still want to say it's big pharma, that's fine. They're a major factor too. So there's a lot of people with interest in this, keeping it illegal. I think we can all agree on that much for sure.
I'm going to say, look, if they're not prosecuting every kid who buys a nickel bag or whatever you call a small quantity today, they're not going to prosecute me either. I mean, there's not going to be any incentive, it seems to me, to avoid the street market.
The government, in their brief, asserts that the possession statute that currently exists provides a deterrent effect, which is their explanation for why they fail to enforce the possession statute that they say is so essential to the regulatory scheme.
One takes your view that this is non-economic activity, so it's outside Congress's commerce power. Then explain to me why, if you have someone similarly situated in a neighboring state, somebody whose doctor says this person needs marijuana to live, but that state doesn't have a compassionate use act. It's just as isolated, no purchase, no sale, grown at home, good friend grows it, and yet you say Congress could regulate that, if I understand your brief properly.
Yes, Your Honor, because that's the second step of the analysis. The first step of the analysis is the economic, non-economic. If the court stops there, then they could also apply in these other states. But then if the court adopts...
But if you buy that, so your first answer is yes. On your first argument, it would be equally impermissible for the feds to regulate medical use anywhere.
Yes, Your Honor.
All right, now you're going to have some limiting...
The limiting principle is the one that was identified by the court in Lopez, in which the government is asserting that if it's an essential part of a broader regulation of economic activity to reach this activity, then it may be reached. And the difference between states in which there is a state law enforcement that's confining the class and that there is a discrimination between legal and non-legal use is completely different from a practical enforcement standpoint than a state in which there is no differentiation. Just think of the existence, for example, of identification cards, which the state of California is going to be issuing like driver's license cards.
Yeah, but it doesn't right now, and that doesn't make the scheme less valid in your view.
Well, but this is the sort of regulation, the sort of effectiveness of the regulation that will be at issue and which is, in fact, I believe the court should be in the position of trusting the state of California to be able to administer its regime. There is no regime in other states to trust, and therefore the argument that it is necessary to reach that activity and a lot of other activity in states in which the states are not attempting to pursue the health of their citizens, the goal of preserving the health of their citizens this way, that would fall under the exception which this court suggested in Lopez and Morgan.
This is a new framework, I take it, and it's very interesting. And one of the things that interests me, I guess on your framework, Lopez should have come out my way.
Well,
it's essential to regulate guns in schools as part of a national gun control regulatory.
Justice Breyer, that's the reason why that exception has to be narrowly treated, so it doesn't reach your result. If that exception were treated as broadly as you suggested that it should be in your dissent in Morrison, then the game is up. The exception will swallow the rule. And Lopez...
Juan says, here in Texas, the legislature decriminalized possession of small quantities of marijuana by accident. Yeah, I've heard about that. I need to look into that a little bit more. Not for the least of reasons that I was considering moving to Texas, so I need to know more about this exception so that I can perhaps... never mind. Let's carry on. Breyer is interesting, but I still like him more than Souter. Souter was so dry, and so he's just hard to listen to. But yeah, Breyer is with his hypotheticals. He isn't really interesting. He does it all the time, so it's that's Breyer.
And Morrison will be limited to their facts.
I thought we didn't.
I was looking at moving at Austin specifically. Austin was pretty fun. I had a good time when I was there, and I don't mind the hot weather. I've grew up in South Carolina, and I'm used to some heat, so it'd be fun. Yeah.
Need to reach all that here for the reason that the connection here, which is an enforcement-related connection and a market-related connection, is actually, I have to confess, a little more obvious and a little more close than what I had to say in Lopez was the connection between guns, education, communities, and business. So I would have thought, given the And I believe that, but that was far further than this, which is just direct.
But this case is completely unlike those cases. This case is completely isolated. In Lopez, that gun probably did come through interstate commerce. Not that I believe it should have made any difference, but it probably did. Here we're talking about substances that don't. So there's just no literal connection between this class of activities and this interstate market.
We didn't decide that in Lopez on the basis of whether the gun had come in interstate commerce. If the statute in question had applied only to guns that had been transported in interstate commerce, the case might have come out differently.
No doubt. And I wasn't suggesting otherwise, Justice Scalia. I'm just suggesting that here we have exactly that if there had been that interstate connection in Lopez, the case might have come out different. There is no interstate connection whatsoever in this class of cases. None. The only way to make it an interstate connection is through some sort of hypothetical economic substitution effect in which somebody who's doing something over here is going to have an effect on somebody else who's doing something over there. There is no connection.
Sounds like Wickard to me.
Evil Tribble says the rainwater used to grow from the grass was from interstate clouds. Therefore, Commerce Clause was meaningless. Well, you say that, but there is, what is it called, riparian rights or riparian rights, basically water rights, and there are actually laws in some states. I don't know if there's anything federal. Well, there is a lot federal actually dealing with allocation of water from rivers and stuff, and like divvying up Colorado River, for example. But there's laws in some states dealing with it making it illegal to collect your own rainwater that falls on your own land to use. You have to let it fall to the ground. So water rights, riparian rights are an interesting topic in certain Western states. So don't joke too much because it's more a fertile area of law. Ha ha ha. Fertile. Nice joke. More fertile area of law than you might initially expect dealing with the rains. Now, I don't know about the rains down in Africa, but I'm sure that they have laws there too.
Hey.
Well, Wickard, Your Honor.
I always used to laugh at Wickard, but that's what Wickard said.
Wickard,
had he not eaten the wheat, it would have been in interstate commerce.
Had that case been about eating wheat, that case would never have arisen.
That's what it was about as far as the court's analysis was concerned. To be sure, there was a lot more use of the wheat on his farm other than just human consumption. But it seems to me the analysis of the case said you take it out of the stream of commerce by growing it yourself. You make it unnecessary for to buy it in interstate commerce.
It's the entire analysis, the entire proof that the court relied upon in Wickard was proof of the economic impact of home-consumed wheat on the farms. And by home-consumed, it did not mean eating at the family table. It meant feeding to your livestock and then putting it at your livestock.
Strange phrase to mean feeding to livestock. But home-consumed is feed it to your pig.
But yes, that's exactly what that general term, how that general term was used in the case.
What the court said, I take it, and I quoted a lot of the language there, and it says that the
Evil Tribble says the judge decided Wickard should be shot, dragged from the court and shot in the street so bad. Well, I want to overturn Wickard v. Filburn. I want to overturn Chevron. I want to overturn Brand X. These are in my wish list of things that Judge Mueller would like to do. So that'll be great. Chevron actually drives me slightly. Chevron might be top of the list because Chevron just drives me completely crazy. We don't have time to go into it because I will rant for 40 minutes about Chevron and we'll never get to the rest of the stream. So let's move on from that. But yeah, Chevron might be first and then Wickard. But Wickard drives me crazy.
Wheat farmers' consumption of homegrown wheat, not the part that went in, quote, though it may not be regarded as commerce,
yes,
end quote, still can be regulated, quote, whatever its nature, so long as, quote, it exerts a substantial economic effect on interstate commerce. Now, that's the language, and I take it that Justice Scalia is exactly right.
And Lynch said, okay, wait, the idea of Wickard is kind of implying that you must buy and not grow it yourself. It wasn't implying it was saying it outright. You must buy. You can't grow it yourself. Yes, that's Wickard v. Filburn. It's illegal to grow it yourself because if you did, you wouldn't buy it from commerce. You must buy it from the stream of commerce. You can't grow it. That's Wickard. Welcome to the party. Yeah.
I thought from that language, it's about the analysis, homegrown wheat, which is not economic, having an effect on something that is.
With all respect.
Which is not commerce. Sorry, not commerce.
With all respect, well, I was about to make that.
Well, the Commerce Clause speaks in terms of commerce.
Right. What the Court was using here was the narrower traditional definition of commerce that Justice Thomas has been urging this Court to adopt. And they were saying that we are not going to limit ourselves to that narrow definition of commerce. It would include, for example, agriculture and production. That's all going to be reachable, even though it's not commerce in the traditional sense. But what we would call it today, and I believe what the Court correctly called it in Lopez, was economic activity. Production is economic activity. Manufacturing is economic activity. It's not commerce, but it's economic activity that can be reached. And that is the activity. That's not only the activity that Farmer Filburn was engaged in. That was the activity that the statute was aimed at. The statute.
Why is this not economic activity if you use the term in that broad sense? This marijuana.
Evil Tribble says Wickard is commie central planning in the U.S. That's probably a very intelligent comment. And it's probably why the left-wing progressives like it. Because generally speaking, I think the left-wing progressives tend to like governmental power more, all things being considered. At least it's in their own philosophy. At least Republicans hypothetically, or conservatives hypothetically, are concerned about governmental power. The degree to which they're loyal to that is a whole other issue. But the progressives, they like governmental power. And so Wickard v. Filburn goes right in line with that because it gives the government more power to regulate more stuff for progressive causes. So yeah, that's probably why maybe they're not in such a rush to deal with this issue, because they want the government to have more power. So, yeah.
That is grown just like the wheat that was grown in Wickard.
Someone asked about highlighting the text. No, I'm not using a program. This is the highlighting has been done for me, as well as highlighting who's speaking. This is all from Oye. That's O-Y-E-Z. It's pronounced Oye, in case you ever want to know how it's pronounced. Oye, Oye, Oye. All people having business before the court, the Honorable Court of the United States, draw near, for the justices are sitting. God save the United States and this honorable court. O-Y-E-Z. It is an interjection, so it doesn't really have a meaning. It's the same thing as saying, hey, hey. It's Oye. Or hear ye would be another word, but Oye is used in law. So it's oyez.org has these pre-highlighted, so thanks to them.
Since it's grown on the farm, doesn't have to be bought elsewhere, and that makes it an economic activity.
What made it an economic activity in Wickard was the fact that it was part of a commercial enterprise, that it was being used on the farm, not in interstate commerce, but part of the commercial enterprise of the farm.
Again, I don't think that faithfully represents what the opinion said. I think the opinion covered including the amount that he consumed himself and his family consumed.
For whatever it's worth, it's worth remembering that the statute exempted small commercial farms. People who had backyard gardens weren't even included within the regulatory regime. The regulatory regime was about regulating or stopping or restricting the supply of wheat that got into the market or that competed with the market.
Did the opinion make a point of that?
Pardon me?
Did the opinion make a point of that?
It was mentioned in the opinion. It was not a major.
Epic Random World says, I'm bored. This is for old people. I am hurt, Epic Random World. I don't want to be boring, but we want to, at least, this is a legal education channel, and the law can sometimes be boring. We do try to make it a little bit more fun and try to explain things as it's going. But yeah, it's like law. It's like, we have to listen to it so we can listen to the argument, understand what's going on, and explain it. So it's like, so we can understand it. And the nice thing about this is we can see everything that was argued. We can read it. We can understand it. We don't have to. I explain it to you, but you have the benefit of seeing literally what was said. You can see literally the argument. And when we're done with this oral argument, we're going to hear the decision, and then we're going to read at least the syllabus of the decision so we can understand this case. As we are devoting ourselves to tree law today, and this is what we mean by trees, right? That's what they meant by trees. This is tree law. So, yeah, I want to be entertaining, but the law is the law, and how else can we understand the law but by listening to what was said and what was argued so we can understand the tensions of the argument. It's going to the deepest root principles of what it means to be a people, of what it means to be a populace, of what it means to be a society, what it means to be a polis. I find it interesting, but, there's 100 ways to entertain yourself, I guess, if this isn't your cup of tea.
Your point of this opinion. But
I don't think it was a point of the court's analysis at all.
I want to ask this question. What is your view?
And Higgins said, laugh at Justice's really bad jokes. Yeah, as I was trying to explain this in a previous stream, the bar for humor is very, very low at the Supreme Court because, as you would expect, it's a very, very tense environment, right? You have gone through the slog of trial courts, appeal courts, all kinds of stuff. It has been a long, hard slog. And now you are standing as close to the justices as you can get. There's nothing in between you and 9 highest people in this country in terms of law. It's a little intimidating. So it doesn't take much to break the pressure of it. So a little interject. The bar for humor is pretty low. So, but man, I've been there, and when I've been there, and there's a funny line. It's funny. And it wouldn't work at a comedy club, but it's the U.S. Supreme Court. Standards are a little different.
With respect to the impact of the activities concerned in this case on the interstate market for marijuana, is it your view that it will have no impact, that it will increase the interstate demand or decrease the interstate demand? So there are 3 alternatives. Which is the one we should follow?
Can I pick trivial impact? It would have a trivial impact?
If a trivial impact, is it a trivial impact that enhances the price of marijuana or decreases the price of marijuana, in your view?
The only effect it could have on the price would be a slight trivial reduction, if it has any effect at all, because it's going to withdraw users from the illicit drug market. And to the extent that
Higgins said, can he define trivial impact? At least to me, I would define trivial impact as basically the same thing as saying de minimis. It's such a low amount that we can just ignore it. It's such a low amount, we just throw it away. There's not a precise definition, but I'd say it's exactly the same thing as de minimis. So it's so low, we just can't be bothered to care.
They are now in the illicit drug market, and we don't know whether they are.
That would reduce demand and increase price, it seems to me. It's the other way around.
Well, it would reduce demand and reduce prices, I think.
If you reduce demand, you reduce prices? Are you sure?
Yes.
Yeah. Oh, you're right. You're right. Yeah.
Your whole argument for triviality, though, goes...
Okay, see, that's funny. That's funny, man. All right, he's like, you reduce demand, you reduce prices, are you sure? He's like, yes. He's like, oh, you're right. I mean, that's funny, man. How can you not laugh? That's good stuff.
Your whole argument for triviality, though, goes back to your disagreement with the government about how many people are involved, because I take it you accept the assumption that the more people who are involved, if there are millions and millions, it is unlikely that this licensed activity is going to be without an effect on the market. So the whole argument boils down to how many people are going to be involved. You don't accept the government's $100,000 figure. Let me ask you a question that would get to maybe a different number, and that is, do you know how many people there are in California who are undergoing chemotherapy at any given time?
I do not know the answer to that.
Isn't that number going to be indicative of the demand for marijuana?
It could be, Your Honor, but that also illustrates...
But if you accept that, then there's nothing implausible about the government's 100,000 number, is there?
But I don't know, because I don't know the number of people using chemotherapy. But whatever the
How many people are there in California? What's the population?
34 million.
Thank you, Justice.
Lots and lots. 100,000 cancer patients undergoing.
Well, remember, this is 2004, Higgins, so the number's a little different in 2004. So let's assume 34 million was correct in 2004, so let's press on.
Chemotherapy does not seem like an implausible number. And in fact, if that number is a plausible one today, its plausibility reflects, among other things, the fact that there is a controversy as to whether California's law, in fact, is enforceable or not. And there is reason to assume that if we ruled your way, that number would go up. So if you accept that line of argument, then your argument that the effect, whatever it may be, is going to be trivial seems to me unsupportable. Am I missing something?
Well, two things. First of all, whatever number it is, it's going to be confined to people who are sick enough to use this. That is not an infinitely expandable number the way, for example, recreational activity is, where lots of people could just decide to do it. We're talking about people who qualify on a physician's recommendation for this particular activity. That will limit the number. But the amount of the people, the effect on commerce only matters if the Wickard versus Filburn aggregation principle applies to the class of activities in this case. And it does not apply to the class of activities in this case if they are non-economic, as we assert that they are.
But that is circular reasoning, because your whole argument that it's non-economic is based on the claim that the numbers are so few, the number of people involved from which you could generalize are so few, that it would not be reasonable to infer an effect on the market. If there would be a large market effect, it makes no more sense to call this non-economic than Filburn's use non-economic.
Lopez and Morrison stand for the proposition that activities that simply have an effect on the market are not necessary. That does not make them economic. This Court rejected that proposition, that just because an activity has an effect, an economic effect, makes the activity itself economic. It adopted a principle that's less than
remote economic effect.
It was inference upon inference upon inference. That's not what we're talking about here.
But whether an activity is economic, you have to look to the activity itself. And an economic activity is one that's associated with sale, exchange, barter, the production of things for sale and exchange, barter. This whole Court's jurisprudence since the New Deal has been premised on the ability to tell the difference between economic activity on the one hand and personal liberty on the other.
But your whole jurisprudence in this case is premised on the assumption that we have got to identify the entire range of potential effect based on the particular character of two individuals in their supply of marijuana. And the whole point of this argument is that does not seem to be a realistic premise on which to base constitutional law.
The premise of our economic claim is the nature of the activity involved, not necessarily its effect, but the kind of activity that it is. The idea, for example, prostitution is an economic activity. Marital relations is not an economic activity. We could be talking about virtually the same act, and there is.
Marital relations is not an economic activity. I mean, I don't know if I want to quibble that deeply or not, but marriage does have significant economic aspects to it, as I think every family lawyer would be able to tell you. So I'm not 100% sure about that. And also, as we remember from our discussion about the North Carolina alienation of affection case, loss of consortium, which is other words for loss of sex, is a tort that's recognized in North Carolina. So you can sue for loss of sex when your wife cheats on you with another person. So there's some economic impact there as well. So for all you married people out there, I guess you're engaging in commerce in your, activities. So there's that. Let's press on.
Is a market overhang from private sexual relations to prostitution. But we don't say that because there is a market for prostitution, that therefore everything that is not in that market is economic. We look at the activities and we separate.
I can ask you one question about the activity, which was brought up before, and I just might be relevant. I've never understood this. I'm not an expert. I don't honestly know, if I really think about it, despite all the papers and so forth, whether it's true that medical marijuana is helpful to people in ways that pills are not. I really don't know. So I would have thought that the people like your clients, who have a strong view about it, would go to the FDA and they would say to the FDA, take this off the list. You must take it off the list if it has an accepted medical use and it isn't lacking in safety. The FDA will say yes or it will say no. If it says yes, they win. If they say no, they can come right into court and say that's an abuse of discretion. The court says yes or no. If it says yes, they win. If it says no, it must be because it wasn't an abuse of discretion, in which case I, as a judge and probably as a person, would think it isn't true that marijuana has some kind of special use. So that would seem to me to be the obvious way to get what they want. That seems to me to be relevant to the correct characterization. And while the FDA can make mistakes, I guess medicine by regulation is better than medicine by referendum.
I'm not sure the FDA can change the classification of marijuana even if it wanted to, because I believe it's hard-coded into the Controlled Substances Act. So I don't think you can petition the FDA. Even if the FDA wanted to, they can't, because it's hard-coded. So I'm not sure what they're talking about there.
Well,
so that's, I just want to know why.
Well, Your Honor, first of all, that whole process wouldn't dictate what the power of Congress is to reach this activity.
That's all true, but as long as that hasn't been done, don't I have to take this case on the assumption that there is no such thing as medical marijuana?
Ewan Marshall says they can reschedule it. Are you sure? I believe the attorney. It's been a long time since I've read the act, so my memory is not sharp. I seem to vaguely recall the attorney general has some power to re-regulate by his action, but I don't know if the FDA can do it. This has been a long time, and many states have legalized it. We're not talking about state law; we're talking about federal law. So, yeah, the states that have legalized it, it's still illegal federally. So all you people in all the states where marijuana is legal, as far as the federal government's concerned, you're still breaking the law. So, yeah, I don't think the FDA can do this. I think the Attorney General can. The DEA would never let them. But I don't think the FDA can re-regulate it. Yeah. The Attorney General argument was first that they could. It's been a long time since I read the Controlled Substances Act, so I'm not gonna die on this hill. I don't know for sure.
Special and necessary.
I would simply
if it had been done, maybe I shouldn't make that.
I would simply ask Your Honor to read the amicus brief by Rick Doblin, which describes the government's obstruction of scientific research that would establish the safety and efficacy of cannabis by denying supplies of cannabis for medical experimentation. And then I ask Your Honor to read the Institute for Medicine's report that both the government and we have relied upon in our briefs. There has been no impeachment of this report by the National Academy of Sciences on the medical effect. And what they say is that what information we have is that cannabis does have a substantial medical effect. Smoked cannabis does carry with it harms associated with it, as General Clement correctly pointed out. It does carry with it these ancillary harms. But when people are sick and people are suffering and people are dying, they may be willing to run the risk of these long-term harms in order to get the immediate relief, the life-saving relief that cannabis has demonstrably been able to provide. I just ask Your Honor to look at that, which is in the record.
Are prescriptions under California law limited only to those people with life-threatening illnesses?
They are limited to a list of illnesses that are in the statute.
Some of the illnesses,
some of which are life-threatening and some of which are not, Your Honor.
In one plaintiff's case, I think there isn't a life-threatening.
That's correct, Your Honor. She has severe back spasms and pain that cannot be controlled by conventional medicine. She's a law-abiding citizen. This goes back to the issue of what the incentives there are that are created by this. This is a law-abiding woman who has never been interested in the illicit drug market.
May I just ask you one procedural question? And this is a suit for an injunction. And it's basically an injunction against a criminal prosecution.
And seizure of these plants.
There's an old saying in equity that courts don't enjoin criminal prosecutions. So how is your injunction suit appropriate, given that old saying meant that you have to make your defense in the criminal proceeding and not enjoin its operation?
Well, it is, and we're seeking an injunction to prevent the enforcement of the statute against these two persons, which includes forfeiture, which has already happened in this case. We've already had Diane Monson's plant seized by the Drug Enforcement Authority. That is not something that has anything to do with criminal prosecution, and yet that puts at risk her supply of medicine, the supply of medicine she needs to get by, to relieve her suffering. I see my time is up. Thank you.
Thank you, Mr. Barnett. General Clement, you have 4 minutes.
I just want to take note here that Stevens is doing all the introductions, so that means Rehnquist, because the Stevens would be the most senior justice. And the way I know that is because he's sitting to his right, and then alternates order in case you ever want to know who's most senior and most so Breyer is the most junior at this point. But anyways, so Stevens is doing the introductions, which means Rehnquist was not. I'm not sure why Rehnquist was not. Maybe we'll see that when we have the decision. But just an interesting note that Stevens is doing that. He's essentially acting Chief Justice, I guess, at this particular moment. Goodbye, Sean. Thanks for dropping by. Glad to have you.
Thank you, Justice Stevens, and may it please the Court. As I understand respondents' position, it's effectively that their clients and clients like them in their use of medical marijuana is somehow so hermetically sealed from the rest of the market on marijuana that it has no effect on that market on marijuana and no effect on the government's overall regulatory regime. And I understand that to be true largely because of state law. And one of the many problems with that mode of analysis is that the state law is not designed only to carve out those transactions that have no effect on interstate commerce or no effect on the federal regulatory regime. Proposition 215 was not passed as an exercise in cooperative federalism. It was passed as an effort to make medical marijuana lawful to possess, whether you bought it in interstate commerce, whether you bought it with the marijuana having traveled in interstate commerce, whether you bought it, whether you grew it yourself. There's a fundamental mismatch with their theory that really, I think, undermines their theory. Now, there's the question now about what kind of impact this would have on the federal enforcement scheme. Now, we in our reply brief try to use the numbers from one of respondents' own amici, and we suggest that there's 100,000 people that might be lawful medical users if their position prevails. Now, obviously, this is all an effort in sort of counterfactual speculation, so the numbers may be a bit off. But they suggest that our own government numbers are somehow better, and they cite them on page 18 of the red brief. But the only numbers on the red brief for California suggest that in the 4 counties for which their data, there was 0.5% of the people used marijuana. Now, if you extend that out statewide to the 34 million people in California, that gives you 170,000 people. So their numbers using the government numbers actually give you more potentially affected people. I think in trying to figure out how many people would be affected, it's worth considering what medical conditions are covered. And this responds to Justice Kennedy's last question. Is this just limited to AIDS or people with terminal cancer? And it's not. And if you want to look at what is covered as a serious medical condition under the statute, you can turn to page 7A of the red brief, in the appendix to the red brief, and it suggests that a serious medical condition, there's a catch-all at the end that includes subsection 12, any other chronic or persistent medical system that, if not alleviated, may cause serious harm to the patient's safety or physical or mental health. Now, I think that is an exceedingly broad definition of a serious medical condition for which somebody could get a recommendation for marijuana for medical uses. Another point worth considering in considering the impact on the federal regulatory regime or the effectiveness of California in preventing any diversion is to take a look at 2 cases we cite in our reply brief. One is the People against Raich. There's somebody who's arrested with 19 ounces, over a pound of marijuana. They're packaged such that he has 1 small bag in his pocket, 6 other small bags wrapped with a scale in his backpack, 2 other larger bags in that backpack, and then a pound wrapped in a shirt in the back of his truck. And yet the appellate court in California said that he was entitled to go to the jury with the theory that that was for medical use. The fact that he had a scale and the fact that it was packaged the way it was could be explained to the jury because he just bought in it, and that he used the scale to make sure he wasn't ripped off. I think that shows that it's going to be very hard to enforce the regulatory regime. The other case in the reply brief worth mentioning is the Santa Cruz case, because that's a case where a federal district court, after Raich came out, said that it could not enforce the DEA and the Controlled Substances Act against a 250-person cooperative. And that just shows that this is not something that will be limited to 1 or 2 users at a time, but will have a substantial impact on the government's ability to enforce the Controlled Substances Act. Thank you.
Thank you, General Clement. The case is submitted. We'll hear argument.
All right, cool. So that was the end of the oral argument. Now we're going to hear something that is not often heard, which is the oral announcement of the decision. And the reason it's not often heard is that it's not, first of all, when they release the decision, it has nothing to do with when they release the audio of the decision. So it's not timely. Even today, even under the current regime as it currently exists, they don't release the audio of oral arguments, or I apologize, they don't release the audio of the decisions until the end of the term. So if the Supreme Court made a decision today, they'd render the decision today, but the audio of them making the decision wouldn't be released until June, by which point it's completely pointless because it's, no longer effective. So you don't often hear it because it's not timely. So we're going to listen to the announcement decision for if no other reason than we don't get a much chance to, and it's contemporaneously relevant to what we're talking about. So just to show by way of example, to show you what I'm talking about, this case was argued on November the 29th. It was decided on June the 6th, and the audio wouldn't have been released until the end of the month. So that's kind of like something to talk about there. So, yeah. My webcam makes me glow. We're having all kinds of issues with the webcam today, man, okay? And also, we just changed the bulb. So that might be an issue. So we're making stuff. So anyways, we're making do as we go along. We're doing what we can. So let us read to this. Let's listen. That might be the booze, yes.
The opinion of the court in Gonzales versus Raich will be announced by Justice Stevens.
This case comes to us from the Court of Appeals for the Ninth Circuit. California is one of at least 9 states that authorize the use of marijuana for medicinal purposes. The question presented in this case is whether the power vested in Congress by Article 1, Section 8 of the Constitution to make all laws which shall be necessary and proper for carrying into execution its authority to regulate interstate commerce includes the power to prohibit the local cultivation and use of marijuana in compliance with California law. Respondents are seriously ill California residents. Their doctors have concluded, after unsuccessfully prescribing a host of conventional medicines, that marijuana is the only drug available that provides effective treatment. Both women have been using marijuana as a medication for several years pursuant to their doctor's recommendation, and both rely heavily on cannabis to function on a daily basis. While respondents' activities do not violate California law, they do violate the Federal Controlled Substance Act of 1970, a comprehensive regulatory statute which, among other things, categorically prohibits the manufacture, distribution, or possession of marijuana for any purpose. After agents from the Drug Enforcement Administration seized and destroyed their cannabis plants, respondents filed this action to prohibit enforcement of the federal statute to the extent that it prevents them from cultivating marijuana for their personal medical use. The district court denied relief, but the Court of Appeals for the Ninth Circuit held that as applied to their activities, the CSA exceeded Congress' power under the Commerce Clause. Because of the obvious importance of the case, we granted certiorari. The case is extremely troublesome because respondents have made such a strong showing that they will suffer irreparable harm if denied the use of marijuana to treat their serious medical ailments. But the question before us is not whether marijuana does in fact have valid therapeutic purposes.
I would argue the question before you is at least in part whether marijuana does have valid therapeutic purposes, because in order for it to be Schedule I, it has to not have valid therapeutical purposes. So, just saying that, you could have talked about that a little bit would have been good, but let's press on.
Nor whether it is good policy for the federal government to enforce the Controlled Substances Act in these circumstances. Rather, the only question before us is whether Congress has the power to prohibit respondents' activities. California law does not really affect our answer to that question, for it is well settled that the outer limits of congressional power under the Commerce Clause are defined exclusively by federal law. The Supremacy Clause unambiguously provides that if there is any conflict between federal and state law, federal law shall prevail. The federal power can neither be enlarged nor diminished by the exercise or non-exercise of state power. Our case law firmly establishes that Congress has the power to regulate purely local activities when necessary to implement a comprehensive national regulatory program. Neither the fact that respondents use locally grown marijuana for medicinal rather than recreational purposes, nor the fact that their use for such purposes is permitted by California law justifies a constitutionally compelled exemption from the comprehensive regulatory scheme created by the Controlled Substances Act. For the reasons stated at length in an opinion filed with the clerk, we therefore vacate the judgment of the Court of Appeals and remand the case for further proceedings. Justice Scalia has filed an opinion concurring in the judgment. Justice O'Connor has filed a dissenting opinion in which the Chief Justice and Justice Thomas have joined except for Part 3 of it. And Justice Thomas has also filed a dissenting opinion.
All right, so that is the end of the oral announcement of the decision. Thank you, Suze D, for your $19.99 super chat. Thanks for spending your Friday with us. Where's your bourbon? I toast to you. Cheers. Well, today I felt more like in a wine mood. So far we are 3/4 of a way through a bottle of small lot blend Zinfandel from Mendocino County, 2012, Paraducci. I will show you the label and I will read it to you. Recognizing the bold nature of the Zinfandel grape, we select individually vinified small lots of premium varietal Zinfandel grapes to blend in robust, forthright character and luscious flavors. As a family-run vineyard with 80-year legacy of winemaking, we're committed to protecting the health of our vineyards for future generations. To protect our legacy wines, our carbon-neutral winery runs on 100% green power and uses sustainable wine-growing practices that forge deep roots. Excellent. Noted. Fantastic. So, and incidentally, Zinfandel is my favorite red grape. So I am very much enjoying this at the moment. Now we are going to read the syllabus of the decision and maybe some of the dissent as well. But I do want to again say thank you very much, Susan, for your contribution, because it means quite a lot to me to know that I'm making some impacts and people like what I'm doing. It's very, very validating. So I really, really appreciate it. So let us read the syllabus of the decision and we will comment along the way. This is argued 2005, decided 2006. The Controlled Substances Act, which was enacted in 1970 with the main objectives of combating drug abuse and controlling legitimate and illegitimate traffic in controlled substances, criminalizes, among other things, the unauthorized distribution and dispensing of substances classified in any of its 5 schedules. The Attorney General may add, remove, or reschedule substances only after making particular finding, and on scientific and medical matters, he must accept the findings of the Secretary of Health and Human Services. These proceedings must be on the record after an opportunity for comment. The dispute here involves controlled substances listed in Schedule 2. What? Which are generally available only by written prescription. A 1971 regulation promulgated by Attorney General requires that such prescriptions be used for legitimate medical purpose by an individual practitioner acting in the usual course of practice. To prevent diversion of controlled substances, the Controlled Substances Act regulates the activity of physicians who must register in accordance with the rules and regulations promulgated by the Attorney General. I'm not sure why the Attorney General is the one promulgating rules and regulations with respect to physicians. Presumably, that'd be someone who you know is vaguely health related, but sure, why not? The Attorney General, great. To prevent the diversion of controlled substances, it regulates the activities of physicians who must register in accordance with rules. He, the Attorney General, may deny, suspend, or revoke a registration that is relevant here would be inconsistent with the interest. In determining consistency with interest, he must consider 5 factors, including state recommendation, compliance with state, federal, and local laws concerning controlled substances, and public health and safety. The Controlled Substances Act explicitly contemplates a role for states in regulating controlled substances. The Oregon Death with Dignity Act exempts from civil... Oh, I'm reading the wrong fucking decision. God damn it. This is Gonzales v. Oregon, not Gonzales v. Raich. I came to the link from you guys. Now I feel like a damn idiot. I hate my life. Let's try to ignore everything I just said for the last 5 minutes and pretend it didn't happen. Shit. Let's try that again. Gonzales v. Raich, 2005. That's a bad oopsie. Anyways, carrying on. California is at least one of 9 states that authorizes the use of medical marijuana for medicinal purposes. The question presented in this case is whether the power vested by the Congress in Article 1 of the Constitution to make all laws which shall be necessary for the proper carrying of execution of its laws includes the power to prohibit the cultivation and use of marijuana in compliance with law. I need a deep breath. Okay. California has been a pioneer in the regulation of marijuana. In 1913, California was one of the first states to prohibit the sale and possession of marijuana. At the end of the century, California became the first state to authorize the limited use of the drug for medicinal purposes. In 1996, California voters passed Proposition 215, now codified as the Compassionate Use Act of 1996. The proposition was designed to ensure that seriously ill residents of the states have access to marijuana for medical purposes and to encourage federal and state governments to take steps towards ensuring the safe and affordable distribution of drugs to patients in need. The act creates an exemption from criminal prosecution for physicians, as well as patients and primary caregivers who possess or cultivate marijuana for medicinal purposes with the recommendation or approval of a physician. A primary caregiver is a person who has consistently assumed the responsibility for health or safety of the patient. It's ironic that both Gonzales cases dealt with regulation of drugs. One was dealing with the Oregon Death with Dignity Act and drugs, and this also dealt with drugs, which is one of the reasons I didn't notice the error until I was like 3 paragraphs into it. So just interesting that both cases deal with that. So anyways, I probably should have noticed when they mentioned the state Oregon, but yeah. Respondents Angel Raich and Diane Monson are California residents who suffer from a variety of serious medical conditions and have sought to avail themselves of medical marijuana pursuant to the terms of Compassionate Use Act. They are being treated by licensed, board-certified family practitioners who have concluded, after prescribing a host of conventional medicines to treat respondents' conditions and to alleviate their associated symptoms, that marijuana is the only drug available that provides for effective treatment. Both women have been using marijuana as a medication for several years pursuant to doctors' recommendations, and both heavily rely on cannabis to function on a daily basis. Indeed, Reich's physician believes the foregoing cannabis treatments would certainly cause Raich excruciating pain and could prove to be fatal. Respondent Monson cultivates her own marijuana and ingests the drug in a variety of ways, including smoking and using a vaporizer. Vape that shit, baby, yeah. Respondent Raich, by contrast, is unable to cultivate her own and thus relies on 2 caregivers, litigating as John Does, to provide her with locally grown marijuana at no charge. These caregivers also process the cannabis into hashish or keef, and Raich herself processes some of the marijuana into oils, balms, and foods. On August 15, 2002, county deputy sheriffs and agents from the FDA came to the home. After a thorough investigation, the county officials concluded that her use of marijuana was entirely lawful as a matter of California law. Nevertheless, after a 3-hour standoff, the federal agents seized and destroyed all 6 of the plants. 6 marijuana plants, man. 6. Wow. Respondents thereafter brought this action against the Attorney General of the United States and the head of the DEA, seeking injunctive and declaratory relief prohibiting the enforcement of Federal Controlled Substances Act. To the extent it prevents them from possessing, obtaining, or manufacturing cannabis for personal use. In their complaint and supporting affidavits, Raich and Monson described the severity of their afflictions, repeated futile attempts to obtain relief with conventional medicines, the opinions of doctors concerning the need of marijuana. But it has no accepted medical use, guys. Don't you know? It has no accepted medical use because it's Schedule 1. In order to be Schedule 1, it has to have no accepted medical use. So it has no accepted medical use. So Raich and Munson and their physicians are just wrong because it has no accepted medical use, don't you know? Because it's Schedule 1, because there's no accepted medical use. Carrying on. Respondents claim that enforcing the CSA against them would violate the Commerce Clause, Due Process Clause of the Fifth Amendment, 9th, 10th Amendments of the Constitution, and Doctrine of Medicinal Necessity. Yeah. The district court denied the motion. Although the court found the federal enforcement interests waned when compared to the harm they would suffer if denied access, it concluded respondents could not demonstrate a likelihood of success on the legal claim. A divided panel of the Court of Appeals for the Ninth Circuit reversed and ordered the district court to enter a preliminary injunction. The court found the respondents had demonstrated a strong likelihood of success as applied to them. The CSA is an unconstitutional exercise of authority. The Court of Appeals distinguished prior cases upholding the CSA in face of the Commerce Clause by focusing on what they deemed to be separate and distinct classes of activity at issue in this case. The intrastate, see what the court did there? See what the court did there? They used the word intrastate. The Ninth Circuit Court of Appeals has taken the position there is such a thing as intrastate. Intrastate. But we all know that they're wrong. There is no such thing as intrastate. All things are interstate because that's what we know. The interstate non-commercial cultivation and possession of cannabis for personal medical purposes is recommended by a patient physician pursuant to law. The court found the later class of activities different in kind from drug trafficking because interposing a physician's recommendation raises health and safety concerns because this limited use is clearly distinct from the broader market, as well as any broader commercial market, insofar as the medical marijuana in this case is not intended for or does not enter the stream of commerce. It doesn't enter the stream of commerce, guys, but it's interstate commerce anyway. Don't you know what Wickard v. Filburn said about 100 years before this? The majority placed heavy reliance on our decisions in Lopez and Morrison, interpreted by recent circuit precedent to hold a separate class of purely local activities, but it's not, because it's interstate, because things was beyond the reach of federal power. In contrast, the dissenting judge concluded the CSA, as applied to respondents, was clearly valid under the cases. Moreover, he thought simply impossible to distinguish the relevant conduct surrounding the cultivation and use of marijuana crop at issue from the cultivation and use of wheat crop that affected Wickard v. Filburn. Wickard v. Filburn, again, for the win. The obvious importance of this case prompted our grant of certiorari. This case is made difficult by respondents' strong arguments that they will suffer irreparable harm because, despite a Congress finding to the contrary, marijuana does have a valid therapeutic purposes. No, it doesn't. Marijuana said it because Congress said it doesn't. Congress can't be wrong. What are you talking about? The question before us is not whether it's wise to enforce the statute in these circumstances. Okay? Rather, it's whether Congress's power to regulate interstate markets. See how they say interstate? They don't even distinguish. For medical substances encompasses the portions of markets that are supplied with drugs produced and consumed locally. Well-settled law controls our answer. The CSA is a valid exercise of power. Even as applied to the troubling facts of this case, we accord to vacate the judgment of the Court of Appeals. Well, you know, I will have to say this in non-sarcastic mode. It is unfortunately consistent with the state of law that this case is well within the line of precedent. I think the precedent is wrong because I think Wickard is wrong, but he's not wrong in his legal reasoning. So I have to give him credit, even though I really don't want to. It's in line with the precedent. So, yeah. You know, you are the U.S. Supreme Court and could do something about this, but I guess it's not going to happen today. So we got some stuff with dealing with Nixon and some history stuff. We can skip that. Skip the war on drugs, blah, blah, blah. We classified as Schedule 1. Let's see. We'll read a little bit about this. In enacting the CSA, Congress classified marijuana as a Schedule I drug. This preliminary classification was based in part on the recommendation of the Assistant Secretary that marijuana, with an H, must be retained within Schedule I, at least until the completion of certain studies now in underway. That was, 1970? Yeah. So those studies still ongoing, I guess. Schedule I drugs are categorized such as because of their high potential for abuse, lack of any accepted medical use, and absence of any safety for medical treatment. These three factors and varying gradations are also used to categorize other drugs. Okay. Schedule II substances also have a high potential for abuse, but unlike Schedule I drugs, they currently have accepted medical use. So Schedule II substances have accepted medical use. Schedule II substances would include such things as opiates, speed in the form of Ritalin, and cocaine in the form of a nasal anesthetic. So cocaine, speed, and morphine are all Schedule II, but marijuana, no valid use. Vamp Faye says, towards your next bottle of vino, a tipsy Kurt is a funny Kurt. Don't be so hard on yourself. We're all thankful for what you're doing. Well, thank you. You know, I like to be competent, and I hate it when I make a mistake, especially when I make a mistake I should have caught. So, and I do tend to be very hard on myself. It is a trait when I make major mistakes like that. I am very hard on myself. You know, it was a criticism of my ex-girlfriend that I was always very, very hard on myself. Harder on myself than anyone else is. Because, like, I expect a lot of myself. And when I make huge mistakes like that, I get very, very down on myself. Because I'm like, I'm an intelligent person. I shouldn't be that stupid. So, but thank you for the encouragement and for the $10, Vamp Faye. Your contribution is greatly appreciated. And your love is even more appreciated, to be quite honest. So thank you. The CSA provides for periodic updating of schedules. Yeah, we see how well that's gone. And delegates authority to the Attorney General after consultation with the Secretary of Health and Human Services to add, remove, or transfer substances. Despite considerable efforts to reschedule marijuana, it remains a scheduled drug. Yes, 50 years later. Congratulations. I need a bottle of wine for tonight. At least it's legal. Thank God for the 21st Amendment, right? Okay, skip. We'll read a little bit about Wickard, because Wickard's such a pain in the ass. Our decision in Wickard is of particular relevance. In Wickard, we upheld the application of regulations promulgated under the Agricultural Adjustment Act of 1938, in which we were designed to control the volumes of wheat moving in interstate and foreign commerce in order to avoid surplus and consequently abnormal low prices. The regulations established an allotment of 11.1 acres for Filburn's 1941 wheat crop, but he sowed 23 acres. Bad Filburn, intending to use the excess by consuming it on his own farm. Filburn argued, even though we had sustained Congress's power to regulate the production of goods for commerce, that power did not authorize federal regulation of commerce not intended for any part of commerce but wholly consumed. You know, I think Filburn might have had a point, but we are where we are. Justice Jackson's opinion for a unanimous court. So I guess this is proof, if anything, that even when the Supreme Court is unanimous, sometimes they're wrong and sometimes they have a stick up their ass. Justice Jackson wrote, with a unanimous court, the effect of the statute before us is to restrict the amount which may be produced for the market, and the extent to which one may forestall resort to the market by producing his own means for his own needs. Yes, because you produced it, you don't have to go to the market, and that's a problem. That appellee's own contribution for demand for wheat may be trivial itself is not enough to remove him from the scope of federal regulations. It was, someone asked when it was Wickard due to depression. It was 1941. I forget the exact circumstances of why it came to be or where Congress regulated. I forget the factual background, so I'm afraid I cannot intelligently answer that right now. I don't remember specifically why Congress thought it was necessary to guarantee a particular price for wheat, but they did, and that's where we came in the picture. Wickard thus establishes that Congress can regulate purely intrastate activity that is not in itself its commercial. All right. I need to read that again. I need to read that again to you because I need you to listen to this. I need you to understand it, because this is the part where I put my palm in my face and say to myself, I cannot believe the words I'm reading. Wickard thus establishes that Congress can regulate purely intrastate activity that is not itself commercial. He's not wrong. That's what Wickard says. But I seem to remember something vaguely in the Constitution that said something about interstate commerce. This is why people like myself have such a massive problem with Wickard. Purely intrastate activity that is not itself commercial is nevertheless legally interstate commerce. That's Wickard. Yeah. Pressing on, and my webcam just froze again. It cost me an exasperated face, but at least so that I got that going for me. Hold on. All right, we're back. You got so mad the stream froze. Yeah, I got so mad the stream froze. That's basically right. It was good timing on the freezing. At least I got that going for you. The similarities between this case and Wickard are striking. Like the farmer and Wickard, respondents are cultivating for home consumption a fungible commodity to which there's established, albeit illegal, interstate market. Just as the Agricultural Adjustment Act was designed to control the volume of wheat moving in interstate and foreign commerce in order to avoid surplus, and thus consequently control the price, a primary purpose of the CSA is to control the supply and demand of controlled substances both in lawful and unlawful drug markets. In Wickard, we have no difficulty concluding that Congress has a rational basis for concluding that substantial influence in price and markets conditions. Here, too, Congress has a rational basis for concluding that leaving home-consumed marijuana outside federal control would affect the price and market conditions. Vamp Face says that hurt my head just trying to untangle that sentence. Yeah, it's been hurting my head for the better part of 15 years or so at this point. So, welcome to the club. It doesn't get better. It doesn't make sense. The only reason it makes sense is if you're in a position where you want the government to have more power. It makes sense from the position of someone who wants the government to have more power, which I would again note that tends to be more consistent with progressive power, because we need the progressive ideology, because we need the government to have more power to impose progressive ideals. So progressives, generally speaking, want the government to be able to have lots of power in order to do progressive things. But the problem with power is fungible. This is the libertarian point. It's like once you give the power, it's like, I always like the analogy of a dog with a stake and a chain, but it's a stake in the middle of the ground, and so it can go 360. That's how I think about it. It's like the amount of power you give is basically the length of the chain. That's the power. And you say, we want to give the government power so it can reach as far as we want. But the problem is you give it enough length to get where you want to go, and it doesn't necessarily go in that direction. It can go anywhere in the circle. So that's the analogy I always like, is the dog on a chain, and the length of the chain is the amount of power, and shows the fungibility of power. But yeah, conservatives, at least traditionally, and we've not always been loyal to this principle, so I don't fault you for saying we are hypocrites if you think so. But the conservatives, at least traditionally, have been skeptical of government power for exactly this reason. And the libertarians especially, even more so. It's like, you give the government power to do good things, it gives them the power to do bad things. So, anyways, but that's too much philosophy. More concretely, one concerns prompting inclusion of wheat grown for home consumption 1938 Act was rising market prices could draw such wheat into the interstate market, releasing lower market prices. See, it could go into interstate commerce, so that's the same thing. Parallel concern making it appropriate to include marijuana grown for home consumption into the Controlled Substances Act is the likelihood that high demand in the interstate market will draw marijuana into the market. While diversion of homegrown wheat tends to frustrate the federal interest in stabilizing prices by regulating the volume of commercial transactions in the interstate market, excuse me. The diversion of homegrown marijuana tends to frustrate the federal interest in eliminating commercial transactions in the interstate market in their entirety. In both cases, the regulation is squarely within Congress's commerce power because production of commodity meant for home consumption, be it wheat or marijuana, has a substantial effect on supply and demand in the national market. Yeah. Liberty Cause says it's a very good reason that the Constitution grants only limited and defined authorities. I agree with you, Liberty Cause, and it reminds me of an episode from The West Wing called The Supremes, in which the Bartlett administration was considering putting two members on the court at the same time, one of whom was liberal to be Chief Justice and one of whom was conservative. And they were discussing the gay marriage ban under the acts that existed. And the liberal justice pointed out to Toby Ziegler, the conservative justice would have an even easier time striking it down because the conservative justice believed in enumerated powers. The issue is enumerated powers, what Congress can do. Enumerated powers is a consistent conservative philosophy. So, from a conservative proposition, at least from my conservative proposition, I'd be striking this down because I think it's consistent with conservative principles to strike this down. I wouldn't uphold it because I don't think it's consistent with conservative principles to uphold it. The Constitution says you have the power to regulate interstate commerce. This is not interstate commerce. It's local commerce. The Constitution doesn't stretch that far. So to me, being a conservative, being loyal to the text, being loyal to what the text meant at the time, that's what I'm supposed to do, right? Interpret text what it meant. So I'm interpreting the Commerce Clause, like wrote in 1790. What did they mean? They meant goods flowing between states. What it's meant to do in its principle is establish free trade. That's what it's meant to do. It's meant to prohibit any state from putting up barriers, tariffs, trade barriers, regulations that prohibit trade. You can't do that. Free trade. That's what it's meant to do. And Congress has the ability to establish weights, measures, and other regulations to facilitate that. So to me, striking down marijuana's regulation is a conservative principle. It's conservative. It's consistent with interpreting the text as it existed at the time. So that's how I think. Not to mention that I also think that we are a government that should be free. We're a people that should be free. Everything should be legal unless there's a reason not to make it legal. And there's a lot of things that shouldn't be legal where you don't need a lot of thought. And this isn't one of them. So to me, striking down this from the CSA is consistent with conservative principles. But that's how I think about it. Anyways, pressing on. Skip. Oh, this is good. Let's read some more about Wickard so we can hate it some more together. The fact that Wickard's own impact on the market was trivial by itself was not sufficient reason for removing him from the scope of federal regulation. The Secretary of Agriculture is elected to exempt even smaller farms from regulation does not speak to his power to regulate all those whose aggregated products was significant in order to play any role in the court's analysis. Moreover, even though Wickard was indeed a commercial farmer, his activity he engaged in, the cultivation of wheat for home consumption, was not treated by the court as part of his commercial farming operation. Was not treated as part of his commercial farming operation. The cultivation of wheat for home consumption was not treated as part of commercial farming operation. Doesn't matter. It's still interstate commerce because reasons. As you can tell, I'm feeling a little frustrated at this point. Skip. While a statute provided for periodic updating of 5 schedules, we've seen how well that worked. Congress itself made the initial classifications. It identifies 42 opiates. Well, I'm glad that we kept those classifications where we are because we're not like we have an opiate problem. Jesus. 22 opiate derivatives and 17 hallucinogenic substances is Schedule 1. Marijuana is listed as the 10th item in the 3rd subcategory. So, for the record, marijuana is a hallucination substance in case you wanted to know. That classification, unlike the discrete problem established in the Gun Zone Act in 1970, was merely one of many essential parts of a larger regulation of economic activity in which the regulatory scheme could be undercut unless the intrastate activity was regulated. In order to do what we want to do in terms of interstate commerce, we have to regulate intrastate commerce. The Interstate Commerce Clause extends to intrastate commerce. Somehow, reasons. Don't ask me to justify it. Go read Wicker v. Filburn. Maybe we'll cover that on a prior stream. We don't have audio of it, but we could read it. Maybe we'll find a transcript. That'd be good. We could read the transcript together. I have not. I'm almost done with my bottle of wine, and I still have not had enough alcohol for this to make sense. Skip, 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 skip. The exemption for cultivation by patients and caregivers can only increase the supply of marijuana in the market. The likelihood all such production will promptly terminate when the patients recover or precisely match the patient's medical needs during clinical events seems remote. Moreover, that national and international narcotics trade has thrived in the face of vigorous criminal activity efforts suggests no small number of unscrupulous people make use of California's exemptions. Well, maybe that's a reason to reconsider the whole regime altogether, because it's just been a complete and total failure with our $10.5 billion illegal marijuana market. Our attempts to ban the trade have not been so successful. All right, well, that's as much as we need to read. Let's read some dissent. Let's read Justice Thomas's dissent, Let's read Justice Thomas's dissent, because we give Justice Thomas a fair amount of crap sometimes for being a straight-up originalist. But, Justice Thomas... Oh, my name's Kurt, by the way, in case you're wanting to know my name. Or you can call me Blackleaf. Either one's fine. Blackleaf or Kurt. K-U-R-T. But let's read Justice Thomas. We give Justice Thomas a lot of crap sometimes for being a real diehard originalist. But this is a time when he was a diehard originalist and he actually followed it through. So we can all stand together on one occasion and say, Justice Thomas came out with the right opinion. I know all your minds are blown right now that you have to say that. But you have to say that. You have to say Justice Thomas said the right opinion. I know you can't do it, but we're going to do it anyway because he dissented. He actually upheld his principles all the way through. So let's read some of Justice Thomas's dissent. Blackleaf, yes, Blackleaf. B-L-A-C-K-L-E-E-A-F. Yes, Blackleaf, you got it. Leaves that are black. Blackleaf, you got it. Am I familiar with Christina Hall? No, I'm not, but I'll look into it. Uncle Blackleaf is also acceptable, yes. Justice Thomas, dissenting. Respondents Diane Monson and Angel Reich use marijuana that has never been bought or sold, that has never crossed state lines, has no demonstrable effect on the national market for marijuana. If Congress can regulate this under Commerce Clause, then it can regulate virtually anything. The federal government is no longer one of limited and enumerated powers. Preach it, Justice Thomas. Preach it. Even the majority does not argue respondents' conduct itself is commerce among several states. Right. Monson and Reich neither buy nor sell marijuana they consume. They cultivate it entirely in the state of California. It never crosses state lines, much less as part of a commercial transaction. Certainly no evidence from the founding going back to original understanding suggests that commerce includes mere possession of good of some purely personal activity that did not involve trade or exchange of value. How many of you knew that you were secretly Justice Thomas fans? Yeah, welcome to Bizarro World, right? On this understanding of commerce, the Controlled Substances Act regulates a great deal of marijuana trafficking that's both interstate and commercial in character. The CSA does not criminalize only the interstate buying and selling of marijuana. Instead, it bans the entire market, interstate or intrastate, non-commercial or commercial for marijuana. Yeah, exactly. In sum, neither in the enacting of the Controlled Substances Act nor in defending its application to respondents has the government offered any obvious reason why banning medical marijuana's use is necessary to stem the tide of interstate drug activity. Congress's goal in curtailing the interstate drug trade would not plainly be thwarted if it could not apply the CSA to these patients. That is, unless Congress's aim is really to exercise police power of the sort reserved to states in order to eliminate even the intrastate possession and use of marijuana. Yep. Preach it, Brother Thomas. Preach it. The Amazing World of Jaden Stochel says you're stupid. I'm not sure who you're calling stupid. Also, let's take note. I am reading Justice Thomas's opinion, so I'm not sure if you're saying I'm stupid or just Thomas's opinion is stupid. But either way, thank you for your comment. I don't know if I'm stupid because, I don't know, whatever. Carrying on. The majority advances three reasons why the CSA is a legitimate exercise of Congress's authority under the Commerce Clause. First, respondents' conduct taken in the aggregate may substantially affect interstate commerce. Secondly, regulation of the conduct is essential to regulating the market. And third, regulation of the conduct is incidental to regulating the larger market. The majority's treatment of the substantial effects is rootless because it's not tethered to either the Commerce Clause or Necessary and Proper Clause. Under the Commerce Clause, Congress may regulate interstate commerce, not activities that substantially affect interstate commerce, any more than Congress that may regulate activities that do not fall within but affect subjects of its other Article 1 powers. Wow. Enumerated powers, man. It's like a concept. Wow. Deep thoughts. Yeah. Yeah. Liberty Cause says that you're endeavoring to educate. There's nothing stupid about that. I'm always willing to at least accept the premise that I'm stupid. One of the values of freedom of speech is the right to speak your ideas, so that if you're saying stupid ideas, people can correct you, and then you might learn something. So freedom of speech can be valuable to the person speaking, because if their speech is stupid, people will tell them they're stupid, and then maybe they'll learn something. So I exercise my First Amendment rights on the potential that I'm stupid in the hope that I'll learn something. So always a plus. Because I could always be wrong. I try to remain open to being persuaded by evidence. So good times. The majority's rewriting of the Commerce Clause, I just love the way this paragraph is started, because that's like great, It's like, yeah. The majority's rewriting of the Commerce Clause seems to be rooted in the belief that unless Commerce Clause covers the entire web of human activity, Congress will be left powerless to regulate the national economy. The interconnectedness of economic activity is not a modern phenomena unfamiliar to framers. Yeah, interconnectedness of modern activity is not a new problem. It's perhaps enhanced, but the fundamental concept is not new. The founder's constitution, unfounded constitution. Moreover, the framers understood the majority does not appear to fully appreciate. There is danger in concentrating too much as well as too little power in the federal government. The court has carefully avoided stripping Congress of its ability to regulate interstate commerce, but it has casually allowed the federal government to strip states of their ability to regulate intrastate commerce, not to mention a host of local activities like mere drug possession that are not commercial. Justice Thomas thinks that you have the right to have drugs in your own home. Who knew, right? Hey, it's well in line with conservative ideology about enumerated powers. That's like, yeah, pretty much. The majority prevents the state of California from revising drug policies that have concludedly provided much-needed respite to the seriously ill. It does so without any serious inquiry into the necessity for federal regulation or the propriety of displacing state regulations in the area of traditional state concern. The majority's rush to embrace federal power is especially unfortunate, given the importance of showing respect to sovereign states that comprise our federal union. Our federalist system, properly understood, allows California and a growing number of states to decide for themselves how to safeguard the health and welfare of their citizens. I would affirm the judgment of the Court of Appeals. I respectfully dissent. I'd like to take note here, just to further blow your mind, that Justice Thomas is agreeing with the Ninth Circuit's Court of Appeals. This is the thing that's happening, guys. You just gotta fully appreciate that one, man. Yeah, I know. That's the liberty cost us. That's why I think Kurt would appreciate Christina Hall. She's devoted her life to teaching liberty and the Constitution. I will definitely take a look at her work and add her to my list of people that I'm following. Because I think we need, one of the things I think we need is even more people in this field discussing law. I really like that. I have Nate Brody watching this channel. It's one of the reasons I mentioned him earlier, and I'll give again a shout out to Nate Brody. He's a lawyer who has a growing channel himself, about the same size as me. So check him out. You might like his stuff. And, I like other people. Steve Leto is in this field. Rakita Law is in this field. There's Legal Eagle in the field, who's the dominant person in the field. But I feel as the field grows, it only helps us all grow, that we can make the pie grow for everyone. And I think that's really positive. Of course, Leonard French, our favorite copyright lawyer, should not go without mention. But I'm sure you all know about him. So, I think it's valuable. And I like to watch all these people because it helps me become educated, because all these people have something to share. They help inform my knowledge. And then it's like I can also offer commentary and opinion, like I did when I told Legal Eagle that his head was up his butt about the whole Captain Marvel thing, because he doesn't understand, apparently, about battery and self-defense and principles involved in that. But it's like, this is an opportunity for us to build an academy, where we got a bunch of lawyers now participating in a new academy. And so this is really good. So, yeah. Team Trees is the biggest youth collab fundraiser. Let's learn a little bit more about the fundraiser that we're kind of borrowing their name from. So let's learn a little bit more about Team Trees and give them a little bit of love here so that we can let's learn a little bit more about what the fundraiser that we're borrowing their name for, because they want to plant trees. Okay, Team Trees. Let's learn a little bit more about this group. That'll be a good way to end the stream. Team Trees. Help us plant 20 million trees. You can donate to plant trees. I'm going to donate to trees. I will donate trees. $1 plants a tree. I'm going to donate $20 as soon as the stream is over. So I will help plant 20 trees. I think that seems fair. So you can go to teamtrees.org. Let's go back up so you can see their URL. Let's just open this up so you can see it. There you go, teamtrees.org to plant trees. Help us plant trees. Sure, why not? That sounds good. And we got a bunch of people donating to support trees, so we can plant trees and do that. Why not? Let's plant some trees. I like trees. You like trees. They help us breathe. Let's read their fact. How did Team Trees get started? Team Trees started in 2019. We're going to challenge Mr. Beast. Let's move this over so we can read it. I have to change the size of this. Hold on. There we go. What exactly is the Arbor Day Foundation? Arbor Day Foundation is a good group. Does my donation go to Arbor Day Foundation? Yes. For every $1 you donate, we'll plant a tree. Let's find out if the Arbor Day Foundation is a good charity to donate to. So we can go to Charity Navigator, and we'll look up if Arbor Day Foundation is actually a good group to donate to, because I always like to double check these things and see what their financials are. Arbor Day Foundation. Anytime. Arbor Day Foundation. Yeah, 3 stars. It's respectable. So it's always good when someone's soliciting you for charity. I recommend to always use your source of choice. But 86.78 out of 100, they got 3 out of 4 stars. So they're a good group to donate to. They're fine. So we got that going on. So they're a good group to donate to. Where are the trees being planted? They'll provide in a variety of forests. That's cool. Who will plant the trees? Forest Service. Where will the trees be planted? What species is going to be planted? Wherever they needed. Why are you planting new trees instead of preserving ones? It's vitally important to protect, manage, and restore forests. We're providing a restoration because it will help mitigate climate. Cool. Excellent. So yes, you can donate to teamtrees.org if you're interested in using what the Team Trees hashtag was actually designed for and, supporting that. So I think that's as good a place to stop the stream. I want to thank everyone for their kind attention and everything today. It's been really, really valuable. I really appreciate it. So thank you so much. Why does it cost $1 to make a tree? I don't know, but that's where we are. Steve Leto is a statist. I think it's still, I won't comment on whether or not he's a statist or not. I'll just simply say that it's good that we have a multitude of voices so that we can all hear from different people. So, very good. So that's good. And I've received $29 in chat revenue. So I will donate the $29 I received as well as 20 of my own dollars. So I'll make it, I'll even round it up. So I'll make it $50. I'm going to donate $50 to Arbor Day. So I'll donate the $29 I received in chat revenue and 20 of my own dollars and $1 more. So I'll make it $50. So I'll donate $50. Go to teamtrees.org, donate some money, and help make some trees. So it'll be good stuff. So yeah, but that's all for tonight. Yeah, we got 41 viewers at one point tonight, so we definitely are growing. So yeah, Liberty Cause says he's a statist. Again, I'm not going to take a position on that, whether he is a statist or not. I think it's valuable to have his voice as part of the mix. If you find him to be a statist, okay. And if you don't want to listen to him, okay. I just think it's valuable to have different people's voice in the mix and people who want to educate. So, what his views are and things, that's fine. So, whatever. So, we have some verified check marks that say we have some people joining us. Low-Key and Dark Dom have joined us with some verified check mark. Thank you for joining the stream. We were just talking about teamtrees.org. So we were saying that we should donate to teamtrees.org. I'm going to donate $50. So we should all do that. And thank you for Loki and Dark Dom for joining my channel and stinking up the channel. We always appreciate this. This is the Uncle Blackleaf channel. We appreciate things like that here because that's how we roll. Thank you again for your participation in this stream. I hope you had fun. I certainly had a lot of fun. And we will be streaming tomorrow on Saturday for our weekly live stream on Twitch, probably around noon. I'll make an announcement in the Lawful Masses Discord when I'm going to do that for the weekly live stream because I'm on a plane on Sunday, so I can't do it then. And until later, my friends, I hope you're well. Can you take a shot for me to save the trees before you go? Yes, I can. I will. I won't take a shot for you. In fact, I'll even do a proper shot. I'm going to get some bourbon. Hold on. Back to the Heavens Hill stuff. This is Heaven Hill, Tennessee bourbon. Very good. We'll do it night. We'll do it neat tonight. So this one goes out to the trees that allow us to breathe. I support trees. Cheers, everyone. And one for you, Dark Dom, as well. For the trees. For the trees. Good bourbon, too. And trees help make bourbon possible because bourbon, in order to be legally bourbon from the U.S. Code, has to be aged in new white oak. So without new white oak, we could not have bourbon, and that would be very, very sad indeed. So, good stuff. Excellent. Thank you once again for joining us. I love you all. If you haven't already, please subscribe to my channel. I appreciate it. Thank you for your love. Until later, my friends. Cheers and goodbye.